board to give you a short reminder and some instruction for those members of the public who may wish to testify. Ms. Prusak.
Thank you, and good morning. And as the chairman mentioned, I'm sure many of you have already attended some of our past hearings. But just a reminder that we are an independent quasi-judicial board. And this means that we are not the South Coast Air Quality Management District. We are an independently appointed body. Also, our hearings are not like other hearings you may have attended before. This is more like a judicial proceeding, and that's why the chairman has already sworn in those of you who may wish to testify and add your voice to this proceeding. If you have not, there'll be an opportunity for you to be sworn in before any testimony. We are here again in your community to hear from all of you, as well as gas companies' compliance with our order for abatement. And specifically, the chairman has listed the specific items that we have asked the parties to come back today and report to us on. As such, this is a limited hearing. We're going to be hearing evidence of the compliance or non-compliance with the conditions of our modified February 2016 order. And we will determine whether any modifications to the order or further modifications are necessary. All of you will be invited to testify before the board. And since this is like a court proceeding, you'll need to be under oath, as we said before, as is every witness that appears before us. Please also testify from your own personal experience and knowledge, and as in any court proceeding, that will be most helpful testimony that we can use as evidence. And please, again, try to limit your comments to SoCal Gas's compliance or non-compliance with the specific conditions of our modified order, as that is the limit of our jurisdiction today. We cannot act beyond this, and specifically, we have no jurisdiction to shut down the fields or the company today. So thank you, and we look forward to hearing from you today.
Thank you, Ms. Prusak. Before I ask for opening statements from the parties, we did receive 2 additional documents from the public, which I'll mark as exhibits. The first one is an email dated September 12, 2016 from a Maureen Capra, and it will be marked as public exhibit number 105. Yes. Second one is another email, and this one is August 10th, 2016, and it is from Helen Sim Rittenauer, and it will be marked as public exhibit 106. And both of them will be made part of the record of this proceedings. Mr. Sanchez, opening.
Prior to that, Mr. Chair, I also filed 5 exhibits with the clerk and provided copies for the board members, if those can also be marked.
Okay, well, let's mark those now. The first one I have is a well inspection and leak detection protocol, revised September 13th, 2016. That will be marked as exhibit 20 for the district. Second one is a revised air quality notification plan for Aliso Canyon Storage Facility, revised September 13th, 2016. That'll be exhibit 21. The next is a proposed settlement agreement between the people of the state of California and defendant Southern California Gas. It is, the conformed copy is dated September 13th, 2016. That'll be marked as exhibit 22. The next is a single-page document, summary of methane health effects. It'll be marked as exhibit 23. And then finally, we have a copy of an email dated September 7th, 2016. It's got a letterhead that says case anywhere. It is a message from Superior Court, State of California, County of Los Angeles, Department 311. That will be marked as Exhibit, what's the next one? 54. Are there any others?
Nothing further, Mr. Chair.
You may make your opening statement.
Thank you. The status hearing scheduled for today was originally planned for discussion of the parties' progress on the health study. As I represented to the board at the conclusion of the August 6th status hearing and to the chairman at the August 25th pre-hearing teleconference, the district has filed a declaratory relief action in the complex litigation proceedings in which the Aliso Canyon gas leak lawsuits are consolidated before one judge. That is the proper venue for the determination of the scope of the health study to be performed by SoCal Gas. The district has hired outside counsel to represent them in this matter. The hearing board has been provided a copy of that complaint. The district has sought relief for the health study before the judge handling all the Aliso Canyon gas leak litigation. And it's the district's position that the resolution of that matter should be performed before that judge in that matter. Following the August 6th status hearing, two significant court decisions related to the Aliso Canyon gas leak have taken place. First, which has been marked as Exhibit 24, the judge in the consolidated Superior Court actions determined that the residential home cleanup process achieved the goal of getting displaced residents home. He acknowledged that there were imperfections in the cleanup, but they did not appear to have any adverse health effects, and the record on the motion did not show or suggest that any resident is reporting any continuing symptom. Second, in what's been marked as Exhibit 22, in the criminal action filed against SoCal Gas by the LA County DA's office, a proposed settlement agreement was filed in which SoCal Gas agreed to install a methane leak detection system along the southern border fence line of the facility. It will consist of 8 pairs of infrared methane monitors capable of detecting methane crossing the facility into the community. Real-time pressure monitors will be installed on each natural gas storage well in operation. 6 employees will be hired to operate and maintain the monitoring equipment with coverage on a 24-hour, 7-day-a-week basis. These requirements shall be implemented by no later than November 29, 2016. These two decisions address some of the issues raised by the board following the last status hearing. The parties modified the air notification plan as a result of the settlement of the criminal action, and the 50,000 trigger level for reportable release has now been replaced with a 10 ppm methane concentration release level, which is based on a 20-minute time integrated average, as detected and measured by the infrared leak detection system. In addition, the parties modified the well inspection and leak protocol to add language that equipment leaks will be classified and repaired as expeditiously as practicable. The CARB proposed regulations schedule has been delayed. As I represented at the last hearing, these requirements are more stringent than any existing regulations currently required on these type of facilities. And Aliso Canyon will be the first facility implementing these requirements now. The initial protocol proposed by CARB was not scheduled to take effect until 2018, and the second protocol in 2020. The requirements approved by the district are in effect now and will serve as a model for the initiated rulemaking. The daily inspections and record keeping required in the plan, combined with the 10 ppm fence line monitoring system, will provide a robust method to detect any significant emissions that migrate from the facility and have the potential to cause a nuisance to the nearby community. The district prepared and posted on its website a summary of the methane health effects. The district has presented substantial evidence on our nuisance investigation policy and our response to odor complaints in the community. The odor complaint process for phone and online complaints is on the district's website. Thus, the district does not intend to introduce any topic. The air monitoring plan is at phase 3. The plan is dictated by recordings of measurements representative of typical ambient methane levels. If those levels increase on a regular basis, monitoring will increase. If there were an event, the district would adjust the monitoring plan accordingly, not to mention pursue any enforcement action or seek relief before the board as appropriate. It is unknown when the area will be pressurized and outside the district's jurisdiction to determine when wells at the facility will be placed back in service. Finally, Public Exhibit 103 indicated readings from what was labeled as Station 1. Station 1 was operated by CARB, and based on their determination that the measurements were consistently within the established criteria, the fluctuations in measurements were not indicative of any issue or health concern. Thank you.
Thank you very much. Mr. Carroll, opening.
Good morning. Since the previous status hearing on August 6, 2016, SoCal Gas has focused on the two requests that were directed at the company in the hearing board's communication of August 12. Those requests pertain to the leak classification threshold and repair periods in the then approved well inspection and leak detection protocol, and the definition of reportable release or notification trigger in the then approved air quality notification plan. With respect to the well inspection and leak detection protocol, in the absence of any precedent for imposing requirements of this nature on a large natural gas storage facility, both SoCal Gas and District have looked to the rulemaking currently underway by the California Air Resources Board for guidance. The proposed phased approach for classifying and repairing leaks, with one stringent set of requirements taking effect on January 1, 2018, to be followed by even more stringent requirements to take effect January 1, 2020. The hearing board asked that the parties consider whether or not the Aliso Canyon Protocol should require SoCal Gas to implement immediately the 2020 standards. Upon further consideration, SoCal Gas has determined that it is simply not feasible to accelerate by over 3 years the standards proposed by CARB. The phasing in the CARB proposal is very deliberate in recognition of the fact that facilities will need time to develop and implement the procedures necessary to implement those requirements. It provides for nearly a full year following the date of adoption for companies to put the procedures in place to meet the 2018 standards, and for an additional 2 years of experience implementing the aggressive 2018 standards before moving to the even more aggressive 2020 standards. The Aliso Canyon Natural Gas Storage Facility is the largest by far of the storage facilities that will be covered by the proposed CARB rule. It is simply not feasible for this facility to begin immediate implementation of standards that CARB staff has determined are not feasible for implementation until the year 2020. Therefore, SoCal Gas and the district have determined that the Aliso Canyon Protocol should retain the proposed 2018 standards. As it is, that requires the company to implement immediately, as it has already done, requirements that all other facilities will not be required to meet until the year 2018. SoCal Gas is committed to repairing any leaks that are detected as expeditiously as practicable within the specified timeframes. And as Mr. Sanchez just indicated, in response to the inquiry from the hearing board, the protocol has been amended to include specific language to that effect. The amended protocol has been approved by the staff as required by Condition 8 of the abatement order. With respect to the air quality notification plan, the hearing board requested additional justification for setting the threshold for a reportable release of natural gas at 50,000 cubic feet. During discussions with staff following the previous hearing, the staff indicated that their preference would be to establish a threshold based on an ambient concentration of methane of 10 ppm detected at the fence line of the facility. This approach would obviously require deployment of a fence line monitoring network that does not currently exist. As you've heard, pursuant to a settlement agreement entered into with the Los Angeles County District Attorney on behalf of the people of the state of California, which was approved just this past Tuesday by the court, SoCal Gas is now committed to installing such a fence line monitoring system. As a result, SoCal Gas is now able to build upon the system to add a public notification component consistent with the approach preferred by district staff. Therefore, the air quality notification plan has been modified to reflect deployment of the fence line monitoring system and to require public notification in the event of a release of natural gas that results in a reading of 10 ppm or greater on that system. This revised notification trigger replaces the previous 50,000 cubic foot trigger and obviously precludes the need for any further analysis of that threshold as requested by the hearing board. The revised air quality notification plan has also been approved by the district as required by Condition 11 of the abatement order. The changes that have been made to the well inspection and repair protocol and to the air quality notification plan respond to the requests of the hearing board, and the revised plans represent the most protective measures of this type ever put in place for a natural gas storage facility like Aliso Canyon. In many respects, they go well beyond the requirements of the abatement order in ensuring protection of the environment and the residents living in the community surrounding the facility. Thank you.
Thank you, Mr. Carroll. Mr. Sanchez, I don't have any request to speak cards from any elected official or government official. Are there any present government officials or elected officials who wish to speak at this point? Okay. We do have a number of public members who will be speaking after the testimony from the parties. Mr. Sanchez, your first witness.
The district did not intend to produce any witnesses unless the board had specific questions regarding the documents that I've provided.
Board members. Ms. Prusa.
Just to begin with, the issue of inspections. And just so I can phrase the questioning that I've had so that it's clear that it's not intended to impugn the processes by which the district inspects, but merely to provide additional information for at least this hearing board member to evaluate the information that we're receiving regarding the number of complaints and the number of those complaints that are verified. The questions that I had, I believe, posed at the last hearing and that I really did want to understand better is how I wanted to understand how long generally it takes for complaints, once phoned in to the district, for an inspector to show up on the scene, not to, again, impugn how the processes are working, but rather to understand the nature of these complaints and whether they are fleeting in nature or not. So is there an opportunity to understand that and then to further question whether or not it would be possible and, in fact, prudent to have additional inspectors for the short term to respond to any complaints from this facility? And then the final question would be, how many complaints have there been between last hearing and this hearing?
Anyone else have, Ms. Berg?
I just wanted confirmation that the two plans have been approved by the district. I see they were revised on September 13th. That was this week. And if they have not been approved by the district, then they might be approved by the district. And then the exhibit that lists the methane health effects, if you can confirm that that's what's actually on the district website. And as well as, because I don't necessarily know how this process works, the proposed agreement that there's a confirmed copy, date stamped September 13th. Once it has been signed by both parties, it has not been signed by the judge, it appears, and I was just wondering, I just wanted to confirm that the agreement between both parties, even though it's not signed by the judge, means that it will be in effect.
Let me address board members. Go ahead, I'm sorry.
I just want to get all the questions out. Dr. Lerner, did you have any? Senator, did you have any questions that you wish to be addressed?
Right, in the lawsuit and the settlement agreement, there was one section that talked about the health study, and that still has not been agreed upon. And the health, as compared to the health assessment, I think that the gas company is saying they're still not ready and willing to provide for the health study, and also to reimburse the district for the money they spent in their study program. So that's still a disputed area. Am I not? You can respond to that.
That is correct.
Ms. Prussack?
And forgive me if any of this was covered in your opening, Mr. Sanchez, but I was flipping through papers and taking notes, so I may have missed it. But I wasn't sure I heard an update regarding the movement of the district from Phase 2 to Phase 3 of air monitoring, and the concern that more of the air quality monitoring stations have been taken offline or will soon be taken offline, yet my understanding is only 17 of the wells are currently in operation. So I wanted to hear more about that from a witness, and also I wanted to understand the 10 ppm threshold for notification, how that was set and how it compares to 50 MCF. So if I could hear some of that.
Dr. Lerner?
I may have missed this. I just want to go to the specific issue number one that you brought up about the health study and past negotiations. I'm not sure that I heard from either the district or the attorneys for SoCal Gas as to what is the status of that. Maybe I missed it. I find the speaker system here is a little too booming, and your voice, which is wonderful, is not very clear, so perhaps you could bring your mic a little closer. Mr. Carroll, I would appreciate that. That was my question.
Okay, Mr. Sanchez, you have our questions.
Yeah, I think I can address some of them up front, and then I'd ask for a brief recess so we can identify district witnesses who can provide additional testimony. To answer Ms. Bird's questions, the two plans were approved by the district, the air notification and the well leak detection plan. The methane health effects page that I submitted as Exhibit 23 was posted on the district's website, I believe, last week, and so the document I provided is consistent with what's on the district's website. And regarding the health study, the district has filed a request for declaratory relief before the judge who's handling all the Aliso Canyon litigation. So it's the district's position that, based upon the record that's already been established, that we will seek relief, termination of that health study before that judge as part of that litigation. And we've hired outside counsel to represent our interest in pursuing that relief.
Any time frame?
The litigation at this time, the discovery hold has just been lifted as part of that litigation. So we're in the process of determining all the hearing dates. One has not been set yet. And we can report back to the board once that hearing date or timeline for briefing is scheduled.
Thank you. Ms. Bird had one other question.
The question that I had was, at what point is the agreement final? Is it final when the judge signs it, or is it?
Perhaps I can respond to that question, Ms. Bird. The proposed settlement agreement, which has been marked as an exhibit by the district, was approved by the court on September 13th, this past Tuesday. And so I'm not sure at this moment whether we've received a version of that signed by the judge, but when we take a break, we will inquire into that and either get it right away or get it when we do have a signed version. But it was approved by the court on September 13th.
Thank you.
Thank you. We'll take a short recess. How much time do you need?
10 minutes, please, Mr. Chairman.
Okay. We'll reconvene in 10 minutes. My watch says 9:35, so 9:45.
Be taking over for Sandra when she
We are back on the record.
What was the date of the lawsuit?
I've been advised that there are some members of the public who would like to speak, and they've been advised that they will be allowed to speak following the testimony. But also I've been advised that the proceedings are being webcast, so anyone at home can view the proceedings live, or and it will be recorded on the district's website, so this evening or any other time this proceeding can be viewed. Mr. Sanchez?
Thank you, Mr. Chairman. The district would like to call Dr. Sheriff Snyder to testify. Ms. Snyder, Dr. Snyder, did you take the oath?
Yes, I did.
Can you please state and spell your name for the record?
Yes, my first name is Cher, C-H-E-R, Snyder, S-N-Y-D-E-R.
As part of your evaluation of response time in this matter, what are you aware of what the typical response time for a complaint in the district takes?
Typically, on the average, about 2 hours.
And how long was the response time in responding to complaints for Porter Ranch?
And actually, let me qualify that. I would say 2 hours is the average across complaints, but typically we are there at least half the time, if not more often than that, in less than 2 hours.
And what about specifically for responding complaints in Porter Ranch?
The same.
And there was a question from Board Member Prusak on whether additional inspectors could be allocated to respond to this community. Has the district undertaken hiring additional inspectors?
Yes, we have. Within the past month, we have hired 9 new inspectors, and we have plans to hire up to an additional 22 inspectors.
And how many complaints have been received by the district following the last August 5th hearing regarding complaints in Porter Ranch?
Following the last hearing, we've received only 5 air quality complaints from 4 individuals.
And how would you describe the nature of those complaints?
Generally odor complaints alleging a gas-type odor.
And are you aware of a leak reported by SoCal Gas on September 12th?
Yes, I am.
And did the district receive any complaints on that date?
We received no complaints on that day.
Thank you. No further questions.
Mr. Carroll, any questions for the witness?
No, thank you.
Senator, I believe you had a question.
My question would be directed to Mr. Sanchez, and I'll wait as you ask me to wait.
Now you can, is it regarding the inspectors and
Not
what was
regarding the
testified
inspectors.
just now?
No, not regarding the inspectors.
Okay.
Mr. Snyder, how are you?
I'm well, thank you, sir.
Very
How are
good.
you?
What's your position at the AQMD?
I'm an Assistant Deputy Executive Officer in the Office of Compliance and Enforcement.
And what's been your training in that area?
I've been with the district for, about 28 years. My background is a little atypical. I have a doctorate in psychology, experimental psychology, and I also have a law degree.
So you're a lawyer and you have a doctorate in psychology.
Yes, sir.
And that's a pretty good qualification for being in charge of that group that you are.
It seems to have worked out
So
fairly
the competition was, when you're competing for that position, was you came out and talked. That's
Yes,
what
sir.
kind of.
I
All
did.
right.
Ms. Brissett?
I just wanted to confirm what you had testified. So the typical response or the average response time for the SoCal Gas Porter Ranch area, that has been About 2 hours?
It has
same
been
as-
less than 2 hours.
Less than 2 hours?
If you average all of the response times together and you find what the mean is, it's 2 hours.
Okay.
And so we have, in many instances, responded within as little as 5 or 10 minutes.
And in the last just over a month, there have been 5 additional complaints?
That's exactly right.
Okay. And just to be clear, the 9 new inspectors and the intention to hire 22 inspectors, that's overall for the district, is that correct?
That's actually within our office, yes.
Okay, which is a good thing. Okay, thank you.
Ms. Byrd?
Of those 5 complaints, were any verified?
No, ma'am.
Okay, thank you.
Dr. Lerner?
I think I asked you this last time, and I got a bunch of laughs, but do you have an idea about the distribution, the sex distribution of your inspectors? You weren't sure about that when we spoke.
Yes, I do. There are basically twice as many men as women at this point in time.
The total number of inspectors available in the field currently are how many?
I need to go back and count again. We've had some additional retirements, and so I need to double check. We have probably, I would say, at this point, probably about 75 to 80.
So 50 are men and 25 are women.
I'm sorry.
If you say you estimate that there's 75, twice as many men as women. So there'd be 50 men, 25 women, on the basis of a 75 total.
I'd say
Is
that's
that correct?
I'd say that's about right. Yes, sir.
Thank you.
You're welcome.
One final question.
Senator?
To verify a complaint, are they still using the smell test?
Yes, sir. Our policy is that we go out to the field and we verify in the presence of the complainant the odor based on sense of smell. Yes, sir.
And this new protocol, where you're placing all the devices around, that would not be an indicator that something is leaking or not leaking. I mean, your protocol.
I'm not sure about your question.
There's a leak detection protocol that's being employed or used by Southern California Gas Company. So it's positioned around certain distances from the wells.
Right.
And if a complaint comes in, do you at any time determine whether or not a leak has been registered at one of those locations as a verification?
We have different ways of going about addressing the situation. Our leak detection and monitoring plans and some of the other protocols that you've heard about this morning and previously are one approach to being able to handle the problem.
They're what?
They're one approach or one
One
way
approach, okay.
of handling the problem. And they work together with our complaint response program where we're actually being able to detect odors in the field and as they are impacting individuals.
What has been the correlation in the past when they work together? Complaints versus leaks?
I would say that when our monitoring systems are able to detect higher concentrations of emissions, it is more likely that we will be able to verify odors in the field, but it depends on the nature of the compound that we're monitoring for and the extent to which it is an odorous compound.
If that should be the case, such as the one you explained, do you record that data? Do you record that data if there's such as one you explained?
Our monitoring data typically is kept. We have real-time monitors, and then we go out and also take samples as well in some instances, and we can correlate that with odor data as well.
Have you had the occasion, I know you can, but have you had the occasion to correlate the data based on complaints and the leaks as detected?
I think some of the data that appear on our website would show.
No. Have you been able to do that?
I have not personally
I mean,
correlated
has
that
it been
data.
recorded that it's been done?
I don't know that we have necessarily directly correlated that, but we have spoken back and forth, monitoring staff and compliance staff to basically verify and confirm what our relative findings have been. I don't know that we've necessarily tracked that per se over time.
Is it true to say then, notwithstanding the concentration of what's being emitted, there's no way of knowing, or haven't we in the past verified that that complaint is good or bad based on technology?
Well, our protocol for dealing with complaints is different from our protocol for doing monitoring. And so for complaints, we're interested in the impact of an odor or some other air contaminant on individuals in the community. And so we go out and we actually deal with them in terms of their actual experience. Are they detecting an odor, and do they find that odor to be objectionable? And on that basis, then we confirm complaints and take enforcement action as necessary.
Well, you do understand that methane gas, you can't smell it, it's odorless.
That's right. They add an odorant to the gas in order to give it the characteristics.
So your monitoring devices would be able to detect it, but a human being may not, except if they pass out or something.
Because the gas is odorized and the odor detection threshold for mercaptans is low, it's that way purposely when natural gas is odorized. For example, if you had a leak in your house, because the odor threshold is low, you would be able to detect it readily, and then that would, in essence, alert you to taking some action, contacting the gas company, turning off your gas valve, whatever.
You bet. Thank you.
You're welcome.
Thank you. Ms. Prusak?
Just one last question. I think you had mentioned that the 5 complaints were mostly based on odors. Were there any health impacts or effects that were also reported along with the odors?
I don't recall that there were. It was just report of odors.
Thank you.
You testified that you recently added 9 new inspectors and plan to add 22
Yes.
additional. These are for the overall, workforce of the district for inspecting all sources.
Right.
Can you give us an idea of the improvement in the response time to odor complaints here in this situation that you might expect?
Our new inspectors are still fairly new and they're in training, so we were not able to see the full effect of their force in terms of being able to go out and do many of the more complex kind of inspections that our other inspectors do. But they do respond to complaints, and so that's very helpful. One of the things that we're planning on doing is actually targeting our recruitment so that it actually pulls for people who live in this general area. And then that way, they will very likely be assigned to the sectors out here so that response time will be shorter. And that means off-hours response time, too. I don't know if I addressed your question appropriately.
It gives me an idea that we can expect an improvement.
Yes, absolutely.
Any other questions? Mr. Sanchez, any other witnesses?
Yes, the district would like to call Dr. Jason Lowe to testify. Dr. Lowe, can you please state and spell your name for the record? Dr. Lowe.
Jason Lowe, Jason, last name Lowe, Low.
Did you take the oath?
Yes, I did.
What is your position with the district?
I am the Assistant Deputy Executive Officer for the Science Technology Advancement in the Monitoring and Analysis Division.
Are you aware of the leak detection and the air notification plans approved by the district?
Yes, I am.
And did you also review the settlement agreement entered into between SoCal Gas and the District Attorney's Office?
I had a summary presented by you.
Say that. I don't hear you too well. I'm sorry. You got to speak more.
I am familiar with it. I have not reviewed actual documentation.
What phase is the air monitoring plan currently in for the Porter Ranch community?
The current phase is phase 3.
And what does that phase entail?
The phase entails having two fixed sites with continuous methane measurements, H2S measurements, and also it has a scheduled collection of samples for VOC, or volatile organic compound analysis, on a 1 in 6 day schedule. And it also has, as needed, inspections and our mobile methane platform monitoring. However, in practicality, we have continued the mobile methane platform monitoring.
And when is the district scheduled to move from phase 3 to phase 4 of that monitoring plan?
In accordance to the plan, it would be tentatively scheduled for today.
And does the district have the ability to modify or ramp up to, so to say, the monitoring required under that plan based upon observations from the measurements?
And yes, as I had just mentioned, phase 3 is doing that.
And does the district have any oversight of when the wells when any of the wells at the facility are placed back in operation?
No, I do not believe we have that oversight.
And the 10 ppm threshold identified in the air notification plan, is that a preferred measurable method over the 50,000 CFM?
In my opinion, yes.
And is there a correlation between the 50,000 CFM and the 10,000 ppm threshold?
I am not aware of that.
I'm sorry, 10 ppm threshold.
I am not aware of that.
Thank you. No further questions.
Mr. Carroll,
No questions, thank you.
board members, Ms. Prusa.
I did not, I'm sorry. Question and answer regarding the 10 ppm is more stringent? I missed, was there a comparison?
I believe the question was a more preferred method,
Okay.
and in my opinion, yes.
And what is that based on? How is the 10 ppm derived?
I do not know that particular portion. I did not have input to that criteria.
Do you know how it compares to other thresholds that may be in effect, or?
So the only basis of comparison that I would be able to give you is the criteria that was co-developed by SCAQMD and California Air Resources Board as part of their February 16th. So as mentioned, as part of those conditions, we have a criteria set for different levels of methane over a different course of averaging time. And at the time, we wanted to be very, very strict in terms of what we looked at as far as conditions for moving to different monitoring phases and get a better handle of how our monitoring data compares to that. So those conditions, our criteria, were 5 ppm for an instantaneous concentration of methane detected, 4 ppm of methane for an hourly average of methane, and the last criteria was 3 ppm for a 24-hour integrated average.
I just heard today about the September 12th leak, that there were reported to this board 2 leaks, one in July, one in September. Do you know how those leaks compare to the 10 ppm methane standard?
So what I can tell you is that we were made aware of both of those leaks, and I think I had already given testimony to the July one, where I was able to look at our perimeter monitoring. We have our 3 stations that we have one definitely at the near fence line. We have 2 that are just a little bit beyond that. And those stations did not report elevated levels of methane beyond the typical criteria. Same thing occurred this week with the September leak. Looked at the 2 air monitoring stations that were in operation, and I did not see any levels of methane that were beyond the criteria. In addition, we had deployed our mobile methane platform, which also did not recognize any unusually high levels of methane.
Okay, so just so I'm understanding, you did not see elevated levels at the monitoring stations, and you're basing it on criteria pollutants that are actually lower than the 10 ppm, correct? You're looking at 5 ppm instantaneous, 4 ppm hourly average, and 3 ppm 24 hours?
Those were established criteria back in February.
Okay. Regarding the fact that Phase 3 is scheduled to end today, is that correct?
In accordance to the plan, like I said, there's an aspect of a decision to continue at the current level.
Oh, okay, so it will extend beyond today.
Our current plan is to stick with what we're currently doing.
Okay, so phase, just so I understand, Phase 3 and the number of, I understand, 2 monitoring sites will continue.
Correct.
Is there a date by which they're intended to continue, or not quite at this
Well,
point?
there's a date that's stipulated under this order, which I believe is in January. But then there's also a date which we, as South Coast SCAQMD, would perhaps continue ourselves depending on conditions.
And what is that?
I'm sorry?
And what date is that?
I believe we've given a commitment to the schools that we'd be at least there to the end of the school year.
Okay. And do you feel that the current level of monitoring will be sufficient? I understand, given your previous testimony at other hearings, that there have not been significant elevations in the monitoring data, except that public exhibit 103, which maybe we can get to. But the question is, my understanding is that there are only 17 wells that are currently have been allowed to be completely in service and are currently in service. I don't know what the time frame is, and I don't think anyone does know the time frame for when other wells will be placed back in service. Is that being taken into account for when the district may move off of Phase 3?
That is a partial consideration.
Okay. I'm going to dig out my number 103 public exhibit, and I'll leave it to others to have questions.
Ms. Bird?
I read the document for the settlement, but what I was wondering was, is there a coordination between the settlement monitoring that SoCal Gas will be doing and the monitoring that the district will be doing, or will monitoring be limited only to SoCal Gas once that's in effect?
Currently, that's being done independently. It does not mean that in the future that cannot be coordinated.
So will the district also be still monitoring for comparison's sake, or will it?
Well, as presented before, it seems like the monitoring required under that case will be in November, and we will be out there, as I had just previously given testimony, we'll be out there at concurrent times, because we'll be out there at least until June.
Okay, so just so I'm clear, the fact that SoCal Gas will be monitoring will in no way change the monitoring that the district will be doing?
At least with the current commitment we have.
Okay.
Yes, it's not changing.
Yes, okay. Okay, thank you.
Senator?
You have 3 different phases. You may have covered this already while I was looking for the report. You have Phase 1, Phase 2, and Phase 3. You also specify the sites where the monitoring is being done in Phase 1, 2, and 3. It varies from 1 to 2 to 3. And number one, my first question is, how you decided to establish the sites in 1 for monitoring as compared to 2 and 3 down the line, and at one point you reported to the public? Please answer.
Sure. So when having the Phase 1, which is where we had the most fixed air monitoring sites, the intent is to have a good spatial coverage, given the nature of the SS25 leak at the time. Having good coverage for the community was important. As SS25 became sealed, and as the levels of methane had shown consistent levels of typical ambient air, the number of stations as proposed in plan were able to phase down. Between ARB, LA Public Health, and us, we thought it was most protective to be closer.
Say that again, sir. I didn't quite get it.
So between the three agencies, Public Health, California Air Resources Board, and us, we thought it was most protective of the community to remain at the sites that were closer to the facility. So basically near the fence line.
So
those three sites were more consistent with the AQMD run sites, which were the remaining sites as we moved from the different phases. The intent, as I mentioned in my last testimony, was to remain at the two school sites, Castle Bay and also Porter Ranch Community School. However, in working out with the students returning back at Castle Bay, some logistics did not work out between the logistics of the children returning and the use that the school needed to have versus our siting conditions. We need to maintain that our sites have specific conditions to make sure that the air that they are sampling is representative of the air that is in the area.
of course.
So because we couldn't resolve that, we instead left the site that was at the community center in Highlands, which is still the closest site to the facility. So we still think that is a good choice. It's, again, it wasn't in accordance to our intent, but we still think it is a good site to maintain along with the Porter Ranch Community School site.
Look at the differential as I see it. You have phase 1, and you have site number 12, which is not identified in phase 2 or 3. And then in phase number 3, some of those sites are not shown or specified in phase number 3. What's the significant difference? Why you drop site 12, although it is hourly, it's only one per every 3 days.
If you're looking at Table 1...
Look at the report in front of you, you see. Go ahead.
If you're referring to Table 1 of the air monitoring plan, the Table 1 does not specify the site numbers. It specifies the number of sites that are in operation.
I see. So you, like a declining, you have fewer sites in phase 2.
Yes, so as you go from phase 1 to phase 2 to phase 3 and phase 4, there's an incremental decline in the amount of monitoring that's being conducted.
Why?
Because as mentioned, when you do a phased approach, we are looking at the typical levels of concentrations of methane. As we continue to see typical levels, we became more confident that the SS25 well was permanently sealed and showed no evidence of a large-scale leak, whether it be SS25 or another portion of the facility. So the amount of resources to maintain the level of monitoring, we diverted that to other efforts that were related to monitoring, whether it be ongoing after the facility or just looking at other platforms, looking at other technologies, working with some of the academics and others to pursue other potential future types of monitoring for these types of situations.
So in phase 4, all sealed, no problem. You just have a few sites.
So phase 4 is currently would be the least amount of sites.
Indicate that the seal has been accomplished.
We would have evidence. We would be more confident that it has been sealed, but we still wanted to at least maintain some presence to ensure that.
Thank you. Those limits, I think the question I've been asking before is why the minimum reporting limits, how do you establish those limits?
Could you repeat the question?
That's on table 3. Minimum reporting limits.
Yes.
How do you establish the minimum limits?
So many of those reporting limits are based upon the instrument itself. There's a technical specification which is provided by the manufacturer, and when, at least with AQMD, the ones that we implement and use, we go through a validation process, and what that does is it tests to make sure that the specifications are what the vendor states.
At a point in time, you calibrate the instruments to know that they're accurate.
Yes, the instruments, at least the ones by AQMD, were calibrated monthly.
Monthly, and rotated back into the field.
They were actually calibrated in the field.
Okay, all right, thank you.
Any other, Ms. Pusek?
I dug out the Public Exhibit 103, which I believe Mr. Sanchez is showing you now. Can you just explain to us briefly why we should or should not be concerned, or what it means that there were several readings between March and into July of this year that were above the threshold of 4 ppm?
So yes, as the exhibit shows that there are, again, there are some hours. Basically, you can count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 hours that were higher than the AQMD already established criteria. Most of those hours were not at a level of methane that were considered very, very high, and they were not shown to be consistent as far as sustained levels of methane that were higher than that criteria. So we consulted again ARB, Public Health, to see if this was something that would be of concern to discontinue and reduce to basically the next phase from 2 to 3. I think that's where we had the most hesitation and discussion to move from. But through the course of that discussion, we were comfortable moving from phase 2 to phase 3, which removed Station 1 from operation.
So would you say that the levels or the fluctuation in levels are considered comparable or normal to ambient fluctuations that we would see elsewhere?
So relative to the other stations, Station 1 during that time frame was definitely more than what we saw in the other stations. But again, looking at the criteria for what we consider for ambient air and relative to potential health effects of using methane as an indicator, we're using methane as an indicator because methane is a not considered toxic, especially at these levels. So with that decision, they were comfortable moving to phase 3, which left us with the stations that AQMD was running closer to the site.
In this exhibit, there are 5 stations that are shown, and by far, even within the relative, what your testimony regarding how high the higher readings are in Station 1, but it's clear that Station 1 is significantly higher than the other stations. Would you say that Station 1 was the highest reporting station of the ones that were in the earlier
Maybe for
phase?
this time frame, but if you were to look at the prior data, Station 1 would not have been the highest. And also, I should mention that spatial consideration is definitely a concern when looking at a monitoring program. But we do have other measurements. Again, we do run the mobile methane platform through the community as well as on the facility to kind of assess this area still. So even though this one station has been removed, we do have the mobile platform still going through the community. So if we're seeing elevated levels, we would see it also in the mobile platform. And in addition, again, we are looking at other platforms in conjunction with ARB, some other independent vendors, to look at other spatial coverage techniques.
So just to close this line of questioning from me, the last question I have is, when the decision was made for station number 1 to come offline, based on what you're testifying today, was that decision more made based on historically reaching back the levels that were shown in this station as compared with other stations, or how was that decision made, that this was to be taken offline but others were to be left?
Sure. I mean, partially it was to establish more consistency. Again, ARB felt comfortable as a state agency letting the local agency, South Coast AQMD, and we had what we considered really good sites for kind of a longer-term measurement plan. As you may recall, the ARB-run sites were in residential homes, and they were getting feedback that maybe they were outstaying their welcome. So there was considerations that also had to be taken in play. But that's why we also added the coverage of the mobile platform still going through there, and we also still agreed from a scientific perspective the sites closer to the sites were also still being protective of the community.
Thank you.
Any other questions? Thank you very much, Mr. Lowe. Any other witnesses?
No additional witnesses.
Mr. Carroll?
No witnesses. Thank you.
Ms. Prussack?
Give me a minute. Give me a moment. I had a few questions for petition.
We're back on the record.
I had a few questions that I was hoping that SoCal Gas might be able to respond to for me. The questions are, number one, just hearing today about a leak on September 12th, if you could just briefly explain what that leak was and the magnitude of it. Also, if you could just walk us quickly through the changes to what is now Exhibit 21, which is the revised air quality notification plan. And in particular, I believe I see what the changes are, but if you could just confirm or have a witness confirm that the change is, now it is more of a objective infrared methane leak detection system that would trigger the reportable release, and that it's a more streamlined response going directly to the OG as opposed to a chain of command, and whether there are any other changes that I'm missing. And then the last question I had is if you could define for me what is your understanding of the word promptly in regard to notification to recipients of a leak, of a reportable leak?
Yes. With respect to the leak that occurred on September 12th, that was a leak from a pipe. The pipe was not in service, but it was pressurized. Upon discovery of the leak, the pipe was removed from service and remains out of service at this point until the permanent repairs are completed. So the leak ceased upon the pipe being taken out of service shortly after discovery of the leak. In terms of the quantity of natural gas that was released, based on a conservative calculation, the estimate is that the amount of gas was about 1,900 standard cubic feet. And when I say conservative, what I mean by that is that the concentration of the leak was detected, and then an assumption was made that the leak had been occurring for a 24-hour period, and then the 1,900 standard cubic feet was calculated based on that assumption. In fact, based on activity that was in that area prior to the discovery of the leak and the fact that there was no previous detection, the company believed that the leak had been occurring for a relatively short period of time prior to its discovery, but since there was no way of confirming that with certainty, an assumption was used that it had been occurring for a full 24 hours, and that was the basis of the calculation of the 1,900 standard cubic feet of gas released. With respect to the changes to the air quality notification plan, the primary change is the one that you referred to. So it is moving away from the 50,000 standard cubic feet of gas released as the reportable release or the notification trigger. It's defined as reportable release in the plan. We have been using, I think, throughout most of these proceedings, notification trigger is the phrase to refer to that. And so it's eliminating that threshold about which the hearing board had some questions at the previous hearing, and it is replacing that with the 10 ppm threshold. Obviously, the point of measuring and determining whether or not the threshold has exceeded has also changed, whereas previously that would be made at the site of the leak under the fence line monitoring program. Whether or not the trigger has been met is a determination that's made at the fence line of the facility. So we believe that this is a superior approach to the air quality notification plan. We think that it addresses many of the concerns that were expressed at the previous hearing on the part of the board with respect to the 50,000 cubic foot threshold. And specifically, it eliminates some of the, and this goes to your question of what we mean by prompt. The current proposal using the fence line monitoring network and the 10 ppm threshold eliminates much of the human intervention that was required in connection with the 50,000 cubic foot threshold. So under that threshold, it was necessary, upon detection of a leak, for a measurement to be taken, and then for certain assumptions to be made about the duration of the leak, and then a calculation to be performed to determine whether or not the 50,000 cubic foot level had been exceeded. With the new proposal, it's a monitoring system that is set to detect methane at the perimeter, and if there is a detection at 10 ppm or greater, there will be an automatic notification to the operations center at the facility, and the company will then be in a position to implement and execute on the notification process. So we think for a variety of reasons, including that one, and as I said, I think that goes to what we mean by prompt. And I think in terms of how many minutes does that mean, if that's the question, I think that could vary depending on the circumstances. I think that there are some circumstances in which it could be a matter of minutes between the detection at the fence line and the initiation of the public notification. I think there are other circumstances where it could be a longer period of time, depending on the facts. If there is activity that's going on within the facility, and there's need to, or there's activity going on outside of the facility that could result in a reading on the monitors. In some cases, there may be a need for some investigation, and the prompt reporting may take a longer period of time as a result.
Perhaps I should have stopped you earlier. Do you have a witness who can testify to that under oath?
We don't, but what I would say is that I think, if I understand the question, it was more of a legal question in terms of how do we, as the gas company, interpret the word prompt, or promptly as used in the protocol.
It's partly legal, partly factual.
We do not have we had obviously, that question hadn't been posed to us, and we do not have a witness here today that can testify to that.
I had some follow-up questions, which I would think would require a witness to explain this more fully to the board. When you said the pipe, when you were talking about the September 12th leak, you said the pipe you originally testified the pipe was a pipe that was out of service but pressurized. Then when you said it was promptly removed from service, what did you mean? Did you mean it was no longer pressurized?
Correct, correct.
And what are you basing your knowledge for that answer for us today?
This is based on information that was provided to me by operations personnel at the Aliso Canyon facility in anticipation that this question might come up today. I would say that this particular event we think is somewhat outside the scope of the proceedings today, but we anticipate that you might have questions. And so in preparation for that, I did have a conversation with SoCal Gas personnel to provide me some specifics related to that release so that we could respond today if the questions did arise.
Were you provided with information to allow us to assess whether you gave us the amount of methane in SCF? What about as it relates to the 10 ppm threshold for notification? Are you aware whether it was within that, over that threshold, under that threshold?
I'm not, but I would point out that the monitoring network to evaluate whether or not that threshold had been exceeded is not in place. So I guess if I understand your question, I would say no, and it wouldn't have been possible to do that at this time because we don't have the network in place yet.
Fair enough. And that will be in place by November?
That's correct.
Okay. I would have liked a witness to understand prompt a little bit better, because when you say minutes in some circumstances, but longer in others, longer doesn't have any kind of time frame for us. Are you talking about longer than an hour or longer than 24 hours, or do you not know?
I do not know.
Do you know the circumstances in which there would be investigations before a report? My understanding of the reporting to the community is so that they just know. So in time for them to take whatever actions they want to take in response to a leak. So what investigations are you saying may occur, or what are these other factors that may make it longer into a number of minutes?
I don't know, and if I were to, it would be pure speculation to talk about, what those circumstances might be. But I think it is fair to say that there could be circumstances that might result in the initiation of the public notification taking longer in certain cases than in others. I appreciate this line of questioning, but I would just remind the board of how robust this plan is relative to what is called for in the abatement order. The abatement order called for notification to a handful of agencies only, and it did not specify what the threshold would be or how that would be detected, but I don't think any of us, either of the parties, contemplated a brand new state-of-the-art fence line monitoring system being part of that. What we now have is a plan that involves the deployment of a state-of-the-art fence line monitoring system and direct notification to members of the public. The current database for notification includes over 47,000 residents, and so I appreciate the desire to understand the specifics of the plan, but I would just ask you to keep in mind that we really believe that we have gone above and beyond to try to respond to the public and to the hearing board with respect to this particular plan, and that it is far exceeds what's called for in the abatement order, and we think very robust and very comprehensive and protective of the public and informative to the public.
Thank you for that, Mr. Carroll, but with all due respect, I think it's up to this board to determine whether the conditions of the order for abatement have been complied with, and this air quality notification plan is in response to condition 11. I hope I'm holding the correct version. Condition number 11, that within 30 days from issuance of the order, there be a submittal of the air quality notification plan. It's I understand that notice to the public goes beyond, that's in there, and that's appreciated, but it's in the event of a reportable release as defined in the plan. And so I think it's directly relevant to understand what it means to have prompt reporting. I think it's the heart of the reporting plan. And so I'm disappointed. I can't understand it any more than I can today. Thank you.
Ms. Bird?
I just had one follow-up question to questions Ms. Prusak was asking. And you said that you're assuming the release of 1,900 SCF based on a 24-hour period. Is that because there is an inspection every 24 hours?
That is correct.
Okay, I just wanted to confirm. Thank you.
Any other questions? Senator?
Yes. Ms. Prusak was right on target, notwithstanding your comments which followed. For example, the lawsuit filed against you, your company, by the district attorney, specified one cause of action. The cause of action that you failed to notify promptly the fact that you had a leak. And there's a penalty for that. And you stipulated in your settlement agreement if we were to adopt it, which cannot be adopted until all the conditions that is stipulated to are met within that agreement. Now, that being the case, you were attempting to be in compliance with the stipulated agreement, the court that is, by coming up with this systems organization plan. That's what they call it. And you did have a leak sometime, and the more recent one was in September, or was it June, July? The more recent one that was reported in the news, and obviously that would be in violation of this agreement if this agreement were in place at the time, because the public nor those organizations were notified that the leak had occurred. So we're just trying to do everything right because we all want to be good neighbors. But we also want to know that we're working together in good faith. And the fact is, this plan developed after the court action, which is okay. You're doing something about the complaint. So, and you're also specifying at the very end who you're going to notify when there is a problem. You've got area codes, zip codes, and you have organizations that you're going to notify. This is what you're stipulating to. And that's how this report got developed. Now, my question is, when you notify people in certain residential areas like the zip code, and you say you will do that, now, will they be able to opt in or opt out? What's your intention of doing that?
So the way the plan is currently structured, and this was a change that had been made not since the last hearing, but between the last hearing and the one prior to that in response to comments from the public and the hearing board, the current system is an opt-out system as it relates to email. So all of the emails that are in the company's database that has been developed since the leak began are automatically included in the database unless the recipient elects to opt out. With respect to those who have chosen to be notified by phone or text, it is an opt-in. And the reason for that is that is a requirement of federal law that companies are not permitted to have direct communication via text or phone with individual members of the public unless they have affirmatively opted in to receive those. So the vast majority of the parties in the database are email, but 37,000 of the recipients, well, I'm sorry, let me get the exact number. Of the individual residents, and I misstated the number, so let me be clear about this. Of the individual residents who are in the current database to receive notifications, 62,223 of them are by email. So those were automatically included, no requirement for them to opt in. Text is 1,065, and phone calls are 129. Those parties, the text and the phone call recipients, were required to affirmatively opt in as required by federal law.
It says here that release notification enrollment procedure. Individual members of the community in zip codes didn't say anything about, I know I like the idea, or to be notified. That's what you're saying right here. Or do I misunderstand it?
Yes, it's individual members, individual residents residing in the zip codes identified in the plan for which we have email addresses or whom have affirmatively elected to opt in to receive notifications via text or phone.
All right. Okay, thank you.
Any other questions? The board's going to take a 15-minute recess, reconvene at, let's make it 10 to 11. At that time, we'll entertain public testimony. First one will be Mr. John Alford from Congressman Brad Sherman's office. We're in recess at the moment.
So there's no way you heard anything about, by the way, where's the men's room here?
Well, ours is upstairs.
Oh, well, I'm not going upstairs. Well, then we get back here.
There's one that you go out here. Real quick, time's up.
One more general.
So if you're going,
Okay, give me a
okay. We're back on the record. Senator Holden had an additional question for Mr. Carroll.
Mr. Carroll, the question been asked and answered regarding those individuals. You have emails for, you will notify them, and they already opt into the program. That's part of this paragraph. They automatically opt into the program of those individuals that you have the emails and telephone numbers who have complained and who live in these zip codes. right? According, but the one that those individuals that you do not have their email addresses or their phone numbers, and at the same time they live in the same zip code, you said you would provide a method for which they would be notified and where they can opt into the program. Has that method been decided upon yet? Has that method been devised?
Yes. So
what is the method?
So just to be clear, if we, for all of the residents within those zip codes for which we had email addresses in the database, those email addresses in our previous database, those email addresses were entered into the database for notification. With respect to the phone and the text, those parties are required to affirmatively opt in, and the mechanism which you're referring to by which we have notified the public of that is on the Aliso Canyon Updates website, which is where all of the information related to Aliso Canyon and the leak at well SS-25 has been posted since relatively shortly after the leak. And so we have put on that website information about the air quality notification plan and the ability to opt in if the residents so choose. So that's the mechanism. It's via the website.
Approximately how many people live in these zip codes, to your knowledge?
I do not know.
Far exceed the ones that you have email addresses for, I would suspect.
I don't know.
If that were the case, I'm asking you a question now. For proper notification, could you just include in the gas bill you send out each month that they could opt in, and that this program in fact does exist? It gives them an option.
I don't know whether that is something that could be done. I would.
Thank you.
I would just point out, Member Holden, that with respect to the leaks that you were referring to earlier prior to the break, the one that occurred this past Monday, and then the one that was the subject of discussion at a previous hearing that occurred on July 2nd, neither of those leaks exceeded the notification threshold in the air quality notification plan that was in place at that time. And as you recall, I did testify as to our conservative calculation of the amount of gas released this past Monday, and that was obviously well below the 50,000 cubic foot level. So I just wanted to clarify for the record that neither of those leaks triggered the public notification requirements under the plan. Now, with respect to this past Monday, we did provide public notice and initiated the process under the plan on a courtesy basis, even though it wasn't required. We went ahead and did that for the information of the public.
So if you were sued, that would not be a cause of action for being sued because of lack of notification, based on the threshold, you say?
I'm not sure I understand your question. I'm just pointing out that...
You're saying the emission did not exceed 50,000 or 50 what did you say?
50,000 cubic feet of gas.
So in order, before notification, you're required to notify it has to exceed 50,000 per cubic feet of gas. Is that correct?
That was the threshold in plan that existed at that time, yes. That's now been modified as of this week. It's now to the 10 ppm standard that we discussed earlier. But
what is it as of today?
As of today, it's a reading of 10 ppm methane at the, as of today. The plan as it exists, and it has been approved by the district today, includes a threshold of 10 ppm methane as detected at the fence line. That program has not been implemented yet. It'll be implemented as specified in the plan by the end of November, because we need to deploy the fence line monitoring system.
So between 10 parts per million and 50 parts per million, anything under 50 parts per million at that time would not probably cause a health problem. And they decided they want 10 parts per million at this time to be the limit, because anything in excess of that could probably, more likely, cause some inconvenience or environmental problems. That's what they reduced from 50 to 10, you think?
I'm sorry, I'm not sure I understand well, I don't understand the question.
Mr. Wyman.
Well, the numbers are really apples and oranges. And as Dr. Lowe testified, it's really not possible to compare them in terms of stringency or protection. They're very different in terms of how they operate. So it's really not possible, if we'd be making it up, to tell you whether we think one or the other is more stringent. It's just different.
I'm sorry, sir. A reasonable person would say, good question, I would think, that what environment would you like to live in? 50 parts per cubic feet or 10?
They're different units of measurement. It's 50 standard cubic feet on the one hand, 50,000 standard cubic feet at the point of the leak on the one hand, and 10 ppm as measured at the fence line as part of the fence line monitoring system on the other hand. And the district, as Mr. Carroll explained during the break between the hearings, asked the company to consider a fence line concentration as a more reliable, more objective criterion, and we agreed to that, and that is in the approved plan. But it's just completely different. It's a completely different criterion.
Thank you. Any other questions? Okay, we'll go now to the public testimony. We have Mr. John Alford from Congressman Brad Sherman's office.
Congressman Sherman is a resident of Porter Ranch, and he's asked that I add his voice to the chorus of folks who maintain ongoing concerns regarding Aliso Canyon and the way that we...
Would you state your name and indicate whether or not you took the oath?
My name is John Alford. I'm speaking on behalf of Congressman Brad Sherman.
And you took the oath?
I've not taken the oath, but I'm going to read a statement that's his, and I guess we'll have to do that.
Anybody else who did not take the oath and who wishes to testify today, please rise and take the oath. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
You may
Congressman Sherman's words. Too big to fail is too big to exist. The order of abatement naturally focuses on safety measures to be taken at this particular facility. However, we must look at each facility as part of an overall system designed to assure Californians have heating, cooling, and electricity throughout the seasons. Your regulations, together with the regulations of related agencies, such as the California Energy Commission, the California Public Utilities Commission, and the California Independent Systems Operator, need to assure Californians of the following: that the shutdown of any one natural gas storage facility will not adversely affect the statewide economy or cause a significant portion of the state to be without heating, cooling, or electricity. Because we use so much of our natural gas to create electricity, a review of the system includes not only the system for storing and transporting natural gas, but the system for generating and distributing electricity and importing electricity from outside the region. Never again should the residents of Porter Ranch or any other community in California be told that an impaired natural gas storage facility cannot be shut down without risking the reliability of utility service. Safety shutoff valves. Each well should have both a deep subsurface positive pressure safety valve and a surface safety valve. A subsurface safety valve is needed because the rupture in a tube or casing somewhere along the length of the well may not allow it to be shut off by a valve located at the surface of the well. The subsurface safety valve should be deep and positive pressure. By positive pressure, I mean that it must come from the surface to keep the valve open. And if there's any interruption in that pressure due to a malfunction or earthquake or powder outage, the subsurface safety valve should close. In addition to a subsurface safety valve, we should have a safety valve at the surface. That way, if subsurface safety valve does not work, at least the valve could be closed from the top. Monitoring on the web. Each well should have an appropriate gauge and monitor. Monitors should report their findings continuously and electronically so that utilities and state officials can see them on a computer. And the public should be able to see all such electronic reporting monitors online. I understand that some of these suggestions cannot be made immediately, but there's no reason not to phase them in over time. I look forward to working together on improving safety of our storage facilities so that a disaster like Aliso Canyon never happens again. Thank you.
Thank you very much.
Sure.
Senator, Mr. Alford, there's a question for you.
What has Congressman Sherman done in a legislative way to incorporate the ideas that you just expressed?
Well, he's advocated both among his colleagues in the state and federally for both the subsurface safety valve and the positive pressure subsurface safety valve and the safety valve on the top. So this is both with Dogger and then the CPUC when they did their remote hearings here. And then federally, he's seeking the same regulations. So we're watching what takes place in the state. Essentially what's happened is we've regulated separately the way that you transport natural gas and the way that you store natural gas. And we didn't, when we were regulating the way we stored natural gas, we didn't treat it as a toxin. We thought of it like something that could combust, but we didn't think about it as something that could poison a community for months on end. And so what we tried to do is affect, well, what's happening in the state is moving to improve the regulations, in terms of protecting against it's getting out and poisoning the community. We're trying to echo that federally.
Does he have the support of his colleagues who state of California, Southern California?
He has. He's spoken to both the president and the vice president on this, and they've both said, we don't need to wait to pass a law in order to move forward on shifting these regulations. You should move forward on this legislatively. We can move forward with this on the interim. And so, the hope is that we can bring some of these regulations forward just by adjusting the way that we enforce oversight.
Or are you saying he plans to introduce legislation to incorporate these remedies or correct the problem?
There's both going to be a legislative fix and there's an attempt to try to fix it on the regulatory side.
Thank you.
Thanks.
Thank you very much. The next speakers will be Isam Najim, followed by Matt Bakuko, followed by Maureen Capra.
Good morning. My name is Isam Najim, and I'm the president of the board for the Porter Ranch Neighborhood Council, and I'm here speaking on behalf of the Porter Ranch Neighborhood Council. I will try to go through my points as fast as I can. I have a few points to make regarding some of the information that we received today and the material that was distributed and we reviewed. Regarding some of the information about the leaks and about the fact that the fence line monitors that are in place now did not detect those 2 episodes of leaks in July and September. Doesn't that give you pause that the system that we have in place, therefore, has a fatal flaw in the fact that it could not detect anything when those 2 leaks were documented? What else are they not detecting? So we need to take a look at what it is that we're putting in place, because apparently they're not detecting leaks. Another point I want to make regarding Station 1, and Ms. Prusak, thank you for bringing it up today. I believe staff has missed completely the point that we raised about Station 1. The point is that Station 1 was higher than all the other stations. At a minimum, we need to understand why. Before we remove it, we need to understand why. If it's higher, I'm not saying it's coming from the well. The well is capped, I appreciate that. But there are other places that this gas can come from. Certainly there's a level in there. To say that the mobile system did not detect it, and it was just above 2 for a little bit of time, so we're not going to worry about it, is not a good answer. There should be a scientific way to determine whether that reading was true or false. If it's false, that analyzer is not needed. But until we determine that, that analyzer should be in place so we can interpret what's going on. That's my suggestion. Regarding the fence line monitoring criteria of 10 parts per million, it's actually stated in the plan as 10 parts per million for 20 minutes. I see a lot of problems with that approach. First of all, they're telling you we will have this infrared monitoring systems. We don't know how many analyzers it's going to be. They're going to be set up on the fence. This is a 3,600-acre facility. Help me understand how these monitors and how many of them will be in place to actually detect every possible leak that comes through over the fence. I haven't seen any information on that. Are they going to put 1 analyzer where the wind blows? Are they going to put 5, 100? How many? And this is very large. So the idea that the methane is going to blow through that analyzer above 10 ppm is the criteria, is not good enough. There should be a better answer than that. On a windy day, the methane will be dispersed. Does that mean that if it measures 8 ppm for 7 days, that is not a reportable leak, just because it's below the 10 ppm? The gas company kept telling us that methane is lighter than air, and therefore it rises above into the atmosphere before it comes down on the community. So then how is a fence line monitor going to detect the gas that rises up into the air and goes into the atmosphere? The science is not adding up between the monitoring plan and what we understand about the situation. I also want to comment that the monitoring plan says that there will be a limit of 3 years for this plan to be in place. It terminates after 3 years, or if another plan is implemented in place. What happens after 3 years? Does that mean we don't need to know what happens, what leaks happen after the 3-year period? I don't believe AQMD accepts a plan for monitoring that has an end date while the facility is still operating. If I misunderstood that monitoring plan, we'd like to know that. And finally, I want to make a quick point. I'm sorry, I'm running out of time. There seems to be this idea that if we can't smell it, therefore it's not there. And then that if it's a little bit above the background, this has no long-term health effects, so we're not too concerned about it. I gotta tell you, that is not how this situation works. If I release a chemical right now in this room that gives all of you a migraine, but you can't smell it and it's not harmful to your health, does that mean it's okay? The people in the community went through that for 4 months with the idea that it's not toxic, so you shouldn't worry. And if we can't smell it, then obviously you guys are crazy. Those two criteria are not real, and you got to look at it from that perspective, and I apologize for exceeding my time.
Thank you. We will make note of your comments. Thank you.
Thank you.
Happy note. Mr. Bakugo, followed by Maureen Capra, and then Susan Gorman-Chang.
My name is Matt Pacuco. I represent a group called Save Porter Ranch. I'm the president. One quick question. The SoCal gas attorneys are not under oath, is that correct?
I didn't hear.
The SoCal gas attorneys, they are under oath, are not here today.
The attorneys are not under oath.
Okay, thank you. Regarding the sworn testimony by Dr. Snyder from AQMD, she said that there's a 2-hour average response time. She didn't say during what time period that was. Is that over the last 5 years, over the last 2 years, during the blowout? Was it during the last, well, she did mention since August 5th date, the number of complaints. So I'll just use that for an example. She said there were only 5 complaints since August 5th. Mine was one of them. It was over 24 hours before our inspector responded to me. So if we take those other 4 complaints and give them a 1-minute response time each, it's still 4.81 hours average response time. And we know that those other 4 weren't responded to in 1 minute. And we have plenty of other people that can tell you how many times they never heard a response. So maybe did the non-responses even get counted? So basically, that casts doubt on all their verbal testimony. Did they provide you with dates, times, complainants, responders' names, and it's just verbal blah, blah, blah. And just that simple, 8th grade math says that the 2 hours can't even be close to reality. So there's a lot of, when they say that these levels of detection of all the air monitoring are below concern, and according to all the data that we shouldn't be worried about this. But many of the experts have also said that, like Isam just alluded to, that the body can detect things that can't even be smelled, that can't be measured, and that also suggests that the body, like he also said, will respond to stuff that we can't even smell. So the health problems, however, in the community are ongoing, and even and those are not being taken into consideration here. All we hear is a lot of data about about numbers and air quality, but no one's talking about the actual health of what's going on with the people. And we have this health study, which you guys are supposed to be ordering, and it's not happening. We know this is a stall tactic by SoCal Gas. I'll get to that some more in a minute, but let's talk about the mission statement, South Coast Air Quality Management District mission statement. Quote, SCAQMD is committed to undertaking all necessary steps to protect public health from air pollution with sensitivity to the impacts of the actions on community and business. End quote. Protect health first, sensitivity second. Seems like you're more concerned with SoCal Gas agreeing to everything rather than protecting our health. And hence, there's no health study going on yet. You know that the health department survey, Casper survey, found out that 62% of homes, 2 months after the blowout, 62% of homes were still reporting symptoms. And still, we don't have a health study, and still, your mission statement is to protect people's health. So this health study, this stall tactic, are you kidding me? Are they, SoCal Gas, or you, Hearing Board, or AQMD, waiting till enough people move out, sell their homes and move, drop dead for cry eye, forget about their symptoms, memory was gonna, this is a stall tactic, and you seem to have fallen for it. How many, and people are just moving out. I know 4 people personally that moved out. These are the most affected people, and when it comes to the health study, when they're gone, it's going to bring down every indicator in that health study. Give me 1 second here. Okay, yeah. If SoCal Gas was so sure that there's no health problems here, they want to get that health study out of the way and prove it ASAP. So why the big stall? Because they don't want that health study done, because they will be crucified, and you guys are allowing it. I mean, what is a order? Is he just waiting for them to agree order? I'd like to go before a judge and tell him that I don't agree to his come on, give me a break. So, yeah, and regarding all the notifications and stuff, this is just notifying us that we still have problems in our homes, that this facility is still spewing emissions into our homes. None of it actually keeps us safe, and none of that even addresses, again, what the AQMD exists for, protecting our health. Thank you.
Thank you. Maureen Capra, followed by Susan Gorman-Chang.
Hello, again. I'm nervous as usual. Anyway, you have the little packet that I handed in with my letter, and again, there was another fire up there. There's proof here from the LA Fire Department. Last week, there was another fire up there. In my packet, as you know, I've lived there 42 years. My daughter grew up in those days, my granddaughter. I'm really scrambled and very nervous. A lot of people aren't here today because a lot are moving out. It's also opening day for soccer and baseball, so a lot of them couldn't come for that. And I'm missing my grandson's 3-year-old baseball first game and 6-year-old soccer game. So anyway, when we first got during the blowout a few days later, we got the first thing, first call, don't open your windows, don't go outside, shut your windows, shut your doors, and don't go outside. I guess that meant it wasn't dangerous. All right, when I was at court for SoCal Gas the other day, I got a phone call. So I ran outside to get it, and it was SoCal Gas telling me there was a leak. That was the next day. I didn't check my email that night. Of course, I did get an email, but it was late at night, so I didn't check it. But I got the phone call the next day in court for SoCal Gas. So that's how accurate they are. I have had so much muscle pain in my legs, I can't understand. I can barely get up. I live in a 2-story house. I can barely get up my stairs. I go with both hands this way. My doctors can't figure it out. I now have a sinus, a nodule in my sphenoid, which is in my sinus cavity, which I did not have before because I had an MRI last year and I had one this year, and I now have that because my sinuses are acting up. Just before that leak, a week ago, I had such bad headache, and I didn't know why, and at the time I didn't know I had this cyst either. I had such a headache in the front of my head, I didn't know what it was. My husband owns a small business. He has a hair salon. Now, if he had a spill or something like that, he'd be shut out of business like that. Why aren't they? Why can't they build something out of way far away from everybody else and put their so-called natural gas in there? Why does it have to be so close to homes? I was there first. You need to move, not me. There is a difference, you know. There, know what was in those things before you put your natural gas in there. And your fence line you're going to put in, what if it's over above? What if the methane comes over above? Will it show? And that should be publicly. We should be able to log on to your fence line. And you never cleaned my home, and because I never moved, and maybe that's why I'm still sick.
Thank you very much, Ms. Capra.
Thank you for hearing me.
Your
I didn't get to
document
everything.
will be marked as Public Exhibit 108.
Okay, I didn't get to everything, but Susan Gorham Chain will, and there are 3 schools that are really close.
Susan Gorman Chang, followed by Kyoko Ibino, followed by Lori.
Mr. Chairman. Chairman, this is the clerk. I believe that should be Public Exhibit 107.
107. Very good. We'll remark it as 107. Thank you.
Before I begin, I want to make sure you have my packet. It's a memo from Susan Gorman Chang with all the attachments.
We do have it.
Do you have that packet? Okay.
And it'll be marked as Public Exhibit 108.
Okay, tell me when I can begin.
You may proceed. Pardon?
Oh, tell me when I can, the clock starts.
You may proceed.
Okay. Susan Gorman Chang, I'm a resident of Porter Ranch. I want to talk first about condition number 11 in your abatement order.
You took the oath, ma'am?
I'm sorry?
You took the oath?
Yes, I did, just now, yeah. Within condition number 11, I'll read part of it to you, but you have it. Within 10 days from the issuance of this order, SoCal Gas shall provide the district with copies of publicly available emergency response plans prepared pursuant to the state and federal law. Within 30 days of the issuance of this order, SoCal Gas shall submit for approval to the executive office or its designee, and they're supposed to, tell the schools, et cetera. You can read the order yourself. I submit to you that SoCal Gas has failed this condition. They recently proved they only notify some of the public after the fact of the leak. This is not notification. This is like a fire alarm going off after the building is burned down and notifying the public that everyone is okay after the fire is put out. I myself did not receive a notification of this leak, and several others in the community did not either. I did not opt out. I signed up to get the emails. I want to receive the notification. The deadline of the 10 days and the 30 days has passed, and we have no plan. If there were a leak Monday, I, as a private citizen, would have to smell the gas and call the elementary schools, as I did October 26th, because there is still no emergency plan in place. SCAQMD has also failed in their promise to provide continuous air monitoring. Attachment A shows their readings are not up to date, with August 11th, 2016 was the latest on this graph, and attachment B, May 10th, 2016, as the latest date they posted air monitoring. Attachment C shows Argo Scientific air monitoring and shows a spike of 2 a.m. of 5 parts per million. These spikes are documented and occur frequently. These may be acceptable rates for you, but it is not for those of us breathing the air and the methane, because they also contain chemicals embedded in the methane left over in the oil fields. Attachment D talks about an article, new analysis from the Clean Air Task Force of 2025, that American children experience 750,000 asthma attacks each summer, directly attributable to the oil and gas industry. The report, Gasping for Breath, is the first to quantify the effects of smog caused by oil and gas production and distribution. The authors used industry data submitted to the EPA. Lastly, I'd like you to know what's really going on in the hills behind us. SoCal Gas, on their site, states of our total 136 billion cubic feet of storage capacity, 49 billion cubic feet is available to other customers to lease and rent. Yes, that's right. They are leasing out space to the highest bidder in Aliso Canyon. So we do not only have to put up with the leaks from SoCal Gas, we have to breathe its leaks from gas belonging to other entities who are playing arbitrage on the futures market with natural gas. They profit and we pay with our health and our lives. Thank you.
Thank you. Kyoko Hibino, followed by Lori Ivesian, followed by Christina Sikovich.
Hello, Kyoko Hibino. I took an oath. Okay. If everything is back to normal level, why are we still having a health problem? Have you guys taken a look at why and what makes people sick? Besides just making us talk about daily struggle of nosebleed, headache, skin rash, stomach problem, vomit, coughing, and other symptoms, we and our health are completely being ignored. Last hearing in July, I was reading Daily Journal of Health Problems. Today, I and many of us in community are still having the same health problems. And there is no change except more nonsense statement and effort trying to reopen the facility. I was out of country for 10 days recently and I have no problem whatsoever. Came back home, headache returned, and then 2 days later I start having nosebleed. I don't want to have that. I don't want to live like that every day, living in the house. And my indoor cat don't go anywhere but staying home 24/7. Are having the more frequent vomit, nosebleeds, scratching everywhere. You keep saying Port Orange air quality is now back to average level of LA. I don't know what you're referring to, but research says the air in Southern California is deadliest in nation. There are 1,341 pollution-related deaths in LA, Long Beach, and the Glendale area each year. Each death can be avoidable. Please not compare to the air which kills us. How much blood we have to shed from our body to prove there is a big problem here, and how many deaths you are looking for till you start health study.
Thank you. Ms. Prusak has a question for you, ma'am. And other speakers, wait till I dismiss you, because we might have some questions.
Okay. I just have one question. Was your house one of the homes that was cleaned?
Yes.
Okay, thank you.
Yeah, they clean it, and we have to also clean ourselves. We did the clean twice.
Thank you.
Thank you very much. Laureate Ivesian, Christina Sikovich, followed by John Tebow.
Good morning. My name is Lori Avazian. You came close on the pronunciation. It's spelled Lori. Last name is Aivazian. First, I would like to thank the members of the hearing board for considering my testimony today.
You took the oath, ma'am?
I did take the oath. I've been a resident of Porter Ranch for 16 years. My home is located 1.9 miles from the blown-out well SS-25. My home was built in 1969 before SCG took over Aliso Canyon. I did not receive any real estate disclosures that that facility was in existence or was working in the hills above us. My family was terribly impacted by the blowout of SS-25. My husband, my daughter, my yellow lab, my 2 cats and I all suffered severe health impacts from the poison spewed out for 4 months on us. We were lucky enough to be relocated in January. The symptoms were still being treated medically, but did start to abate. Upon our return home, after the county health department mandated cleaning, we continued to suffer health problems and even had new problems like rashes occur, which had not occurred during the blowout. We attributed all these health problems to the blowout and whatever unknown chemicals are still present in our environment and may still be being spewed upon us. I don't have enough time to address the health impact on my family and my pets, two of who are close to death of my pets, but I would like to address the verified notification plan mandated by the SCAQMD abatement order. I received an email in August from SoCal Gas to sign up for reportable releases. I promptly signed up for this notification via the same email address that I have been receiving my Dear Neighbor emails from SoCal Gas at since last January. I then received an additional email from SoCal Gas a week later, which informed me that I was automatically signed up to receive notification unless I opted out. So I did nothing. I trusted that I would be notified whenever there was a reportable release, whatever a reportable release may be. On September 12th, I saw social media blowing up, the social media that I follow for my most important information that seems to be the only way I can get information about the gas leak and the goings-on at Aliso Canyon. I saw social media blow up saying that many residents had been notified that there was a reportable release from Aliso Canyon. They received this prompt notification 6 hours and longer after the leak was discovered. Not only did I not receive a prompt notification of this newest leak, I received no notification at all. I still haven't received any notification. I know that SoCal Gas has my contact information since they promptly notified me via text message, voicemail, on my cell phone and my home phone, and via an email message within hours of the blown-out well being sealed in order to inform me that my relocation would be ending within 24 hours. So I'm confused as to why SoCal Gas is unable to notify me of any reportable release which occur from the storage field.
Thank you very much.
One more sentence. While it's only 20% capacity without any injections occurring, my question is, why do I have to depend on social media to be informed that I'm being poisoned by emissions from the Aliso Canyon facility?
That's a good question. What is the date? What was the date of that social media?
That was September 12th. My cell phone's frozen up, but if I can get it unlocked, I can give you copies of both emails and the dates that the social media was being reported, if you would like.
Thank you very much.
Thank you.
Christina Zikovich, followed by John Peeble, followed by Daryl Gale.
Hello, my name is Christina Zikovich. I did take the oath. First, I'd like to say my biggest concern here today is the health study. The fact that it hasn't been done. As a resident, I'd like to know where exactly in the process. Is it the finances that we're not agreeing upon, or is it the actual study in itself? Where in the process are we besides not having one? Yesterday, our councilman downtown at City Hall said that this is like one carton of cigarettes every second within a 5 miles that children have inhaled. Kids were affected, they're sick, and there's still nothing. Monday, my daughter came home from school and I have a headache. And I'll just drink some water, you're probably dehydrated. But she had to take medicine. And then hours later, I believe it was 9:30 at night, I got the notification. So maybe I might have been a little more sympathetic had I known that there was a leak at the facility. And I felt bad that I wasn't the best mom because I really didn't take her seriously. I thought, oh, she's just complaining. The one study that was done by the health department was the Casper study. And randomly, over 60% of people were still having symptoms. Okay, that was, I believe it was in April or May that was done, I'm not sure. But now we're in September, and nobody's done anything else. That's a long time. Go back and randomly test houses. Let's see, are we still at 60%? Are we at 10%? Nobody knows, and those are answers that we should have, as opposed to going on social media and verifying, oh, you know what, That's why my nose is bleeding. And you got the lady in Granada Hills, you've got the lady in Chatsworth, you've got, the only thing that we have is the social media, and that is horrible. I know people that have reported their symptoms just recently to the health department, and their response is, at this time, please go to SoCal Gas. It's like, we don't want to go back to those people. We don't like them as a neighbor. We don't trust them as a neighbor. Their courtesy notification. It's like, no, that was in the abatement order that you had to do it. That wasn't a courtesy. I would actually appreciate if they would take that off the notification because it is quite insulting. It's not a courteous effort when they email hours later due to a leak on their property. I've decided the correct term would probably be dealing with corporate terrorism. I went to the hearing at Diamond Bar. I was disgusted. I didn't even feel safe walking to my car. The round of people that you guys brought in was disgusting. I could not believe it with my own eyes. And if somebody told me the story, I probably wouldn't have believed it. But I was there. The worst part about it was you guys got all those people to come in and say, oh, the chamber, we support. Thousands of people are going to go without power. The elderly won't be able to have a hot meal ever again because of Porter Ranch residents. Well, guess what? You didn't bring in the Porter Ranch Chatsworth Neighborhood Council because their business was affected 50% minimally during the blowout and up to 2/3. Any questions? I could go on.
Thank you. Members of the audience, I'd appreciate if there was no reaction, applause, or otherwise. This is a quasi-judicial proceeding. I appreciate your cooperation. Next speaker will be Jason Hector, followed by Christina Zitkovich, followed by John Thibault. Okay. Before the next speaker addresses the board, there have been a number of questions asked that deserve an answer. So I think what we're going to do is, after the public testimony, take a lunch recess and ask the parties to come back and address those questions that can be addressed today so that the public can get some answers. Okay? All right, Jason Hector.
Hello. It's a pleasure to be here. I want to thank everybody here, especially the people who came out from the community volunteering their time. Please remember that for each of these people, there's several tens or hundreds of other people who could not be here to voice their opinion. So I hope that you take this. A lot of other people are paid, employees and paid to be here, but these people are all volunteering their time. So I'm one of them. I wanted to bring up one point about the health study. I remember Ms. Prusak was saying that there should be somebody to testify as to what the proposed health study is from the district, and we never got that. And I think that's important because I think it's the National Academy of Sciences or whoever they're proposing could come in here, explain what they're proposing for the health study so we could at least continue to move forward and not just be stalled on this health study, which is tremendously important for our community. We did get fence line monitoring from the $4 million settlement, so we are making progress, and that's what encourages me to continue to come out. I was hopeful that the district would support fence line monitoring. I've been asking for additionally aerial monitoring around this facility. I provided you with the pictures of the LICOR monitoring so you can see where the different spots are. Right as you come up on the road and it elbows, there's a problem spot there. I don't know if it's associated with the well or if it's just coming out of the dirt, but there's several different spots, and we're only getting two times a week the LICOR monitoring around the facility. I think we need to be doing it 5 times, 6 times a week. We need more. Also, I provided to you from the California Air Resources Board the proposed regulations. This is talking about the leaks, the thresholds for leaks. The proposed thresholds are much too low. I think they need to conform with the table number 3, which is starting from 1,000 to 10,000 ppms rather than starting at 25,000. I've also provided, Jason Lowe, I want to thank him for coming to our community and speaking with us. I think ultimately the Air Resources Board regulations are going to kick in. I think we need to bridge that gap, and we should have a starting point of 1,000 ppms, because starting at 25 or 50,000 for leak detection is much too low. At the last hearing, one of the issues that the board raised was how to quantify what is this 50,000 cubic feet. What is that? That was kind of the idea we were trying to grapple with, and I still would like to know, because it seems that it's too large of a threshold to be should be a much lower threshold. I had the pleasure of meeting with a school board member from LAUSD. If I can just finish. The notifications, they didn't get any notifications at the school as far as they know, and I just met with them. And it's only going to one person at the school. I think all the principals in the local schools need to be notified, as well as the environmental health person from the school district. So this notification page here needs to be much broader.
Thank you very much.
Thank you for having our board on there.
Okay. The multi-page document submitted by Mr. Hector will be marked as Public Exhibit 109, and somebody has a question? No. Okay, John Tebow, Daryl Gale, James Henry.
Hello there. Thanks for having me. My name is John Tebow. I did take the oath. I'd like to start now. At the last AQMD meeting, the board had mentioned they wanted to have a methane poisoning person expert here today. I don't think you guys have one. And I just wanted...
Let me respond to that. The district has responded by placing on its website and making an exhibit today. But there is on its website what I had intended, and that is an explanation of the health effects of methane, and it's there for everybody to read.
Very good, sir. I'll take a look at that when I get home. I just wanted to read then real briefly what I experienced last October through January, which is also the classic methane poisoning symptoms as I understand them. Major headaches, major constant heart palpitations, cognitive impairment, dizziness, loss of motor coordination, severe flu-like symptoms, lethargy, discomfort, and also including major gastrointestinal problems. It was quite terrible, so I'm going to definitely look at that link that you provided on your website. I want to say, with all due respect, I do not believe that the earlier testimony of Dr. Snyder was true. I don't think it's possible that their inspectors arrive at an average of 2 hours or less to come to the houses after a complaint. For instance, in late March of 2016, when I called in at 4 p.m., an inspector showed up the next day at 9 a.m. That's 17 hours later. And of the 5 times that I called with a complaint, that was the only time I ever saw an inspector come by in person. So that was 17 hours later. So I also would like to ask the board if they have, or if they can request from Dr. Snyder the list of all the complaints and all the response times. I would like to see for sure if my time is on there and it's included in their 2-hour estimate. So that's something I would like to find out, please. One thing I wanted to mention too, at the last meeting, Julie Prusak was talking to the Aliso Canyon facilities manager and asked the great question, how many leaks are at the facility currently? How many are detected? And so there's now a viral video going out that I believe was put up yesterday on YouTube. It's just a 1-minute video which point blank has that question and has the answer, which is, after a little bit of hemming and hawing, the manager does say an average of 2 leaks a day. So when the press says, oh, there's only been 4 leaks since October, that's not true. There's probably been, 700? So just please remember, it's not just these, please remember that it's constantly leaking. And that's why people are being sick. Let me also mention, too, that it's also my understanding that the DA recently let SoCal Gas plea bargain their way down from a felony to a misdemeanor the other day. I think that's an outrage. And I do believe that the LA Department of Health and the LADA have dropped the ball again on this. And I think you guys are our last hope, so please help us. One last thing I'd like to say, too, is I often wear my American flag t-shirt. You know, I am a proud patriot. I work with a lot of World War II veterans, and I just want to say, how can this be happening in America? Once again, thanks for letting me speak here. Thank you very much.
Dr. Lerner has a question for you.
Actually, I would like, and maybe it's out of turn, but I would like to address this to perhaps Dr. Lowe. You are complaining about people being ill from methane. The question is, if the methane levels are not that high to cause illness, are there any other impurities, any other matter that is associated with the rise in the methane that may be the cause of this illness? This may have been addressed before. It escaped my attention, but your question in your initial part of your statement raises this issue for me. It also raises the issue about formaldehyde, which nobody has talked about this time, but has been talked about last time. I'm wondering if we could ask Dr. Lowe to comment on this. Dr. Lowe.
After lunch, we'll have a session where I'm going to want to limit it to questions relative to the purpose of this hearing, which is to have a hearing on the status of compliance with the order for abatement and any new information regarding that since the last hearing. And I think formaldehyde fits in there.
Mr. Chairman.
Senator?
On the order, health is an issue, and I think that's the question he posed.
That's correct, yeah.
So therefore, he might be on top of that thing.
I didn't say he wasn't. I said that after the lunch, we will have an opportunity to hear from the parties with respect to some of the questions that have been posed today that I think are important questions. And you may recall in my open one this morning, the number one point that we were to hear about was the health study, progress on negotiations on health study. Okay. Thank you. Okay. Did you have anything further, sir?
No, sir, that's it. Thanks for letting me speak today.
Okay. Darrell Gale, followed by James Henry, followed by Melanie DeMont.
Good morning, I'm Darrell Gale, and I did take the oath. I don't live out here. I live in downtown Los Angeles, and I live very close to City Hall. I live in a solar apartment with 115 solar panels on the roof, and I came out here on the red line and then the orange line, and then I walked from the orange line. Yesterday at City Hall, and a few of the people were also here, I was very happy to watch our city council unanimously vote to segue to 100% clean energy. Now, clean energy does not mean non-natural gas. It means solar, it means solar battery storage at night, and it means wind. If you watch CNN, you get constantly bombarded with brainwashing that gas is natural. This major methane leak and the ones that keep following it prove that we cannot keep subjecting the residents and the businesses who live and work around this gas storage facility and those downwind of it to chronic sickness and dead pets. Most of all, we don't know, as people have talked about in the health study, the unknown cumulative effects of living in and breathing in constant methane emissions and whatever else is mixed in with it. We, and I mean us citizens as well as the gas company, need to shut this facility down and learn to survive without it. It can be done. Thank you.
Thank you very much. James Henry, followed by Melanie DeMont, Eleanor Center. Mr. Henry, not present. Mr. Mont.
My name is Melanie DeMont. I live not too far from the leak. I live directly below it. I did take the oath. I am constantly stunned by the fact that Southern California Gas has been allowed to continuously claim that they have a proprietary blend of gases that they don't have to reveal the content of. There have been and are published online numerous studies showing what's in the gas. It's not fresh methane just floating off into the air. It's very heavy. It has many inclusions. It's heavier than air. It lays against the ground and drifts down. I live at a location that is directly below and at the river, the Los Angeles River. I've been very sickened, wakened in the middle of the night, unable to breathe. I have asthma again. I had a pet die. Anyway, the methane that we have is brought in from other states. It's brought in for profit. It's stored there because it's one of the biggest facilities in the U.S. It's not for just the use of people in Los Angeles. Also, as far as notification, which should be rapid, not, taking a long, long time, notification can be done just as it is for inclement weather. We just notify the news and they put it out. If you're in a mudslide area, you know that the mud, you need to watch out for it. If you're in an area affected by the gas, you know immediately. They need to be put to the same kind of regulations as we would for anything, just courtesy notification. It should be going out right over the air immediately, not 10 hours later. The gas gets to my house, which lies 6 miles below the leaking well, in about an hour after a big leak. And it comes down the waterways, it stops at the river, and it pools up. And we have numerous images that have been taken by people from out of the area who have come here as a courtesy and have tested and posted these things online. I do not understand. Also, methane, there are numerous studies on the effects, long-term effects of methane from people living next to garbage dumps, next to large cattle fields. This is not that type of methane, though. This is mined methane. It is full of toxic, cancer-causing compounds. It's very dangerous. It's heavier than air. And methane displaces oxygen. And so you're suffering a constant lack of adequate oxygen when you are exposed to methane, whether it's fresh or mined.
Thank you very much.
Also, where would I have some things I would like to send directly so that you would have them. Where can I send that? On maybe internet?
You can contact the clerk of the board.
The what?
Clerk of the board will provide you an address.
Click it?
Clerk
thank you.
of the board of the South Coast Air Quality Management District.
Thank you.
Thank you. Elaine Semper. Followed by Faith Mir Mira, and Jane Fowler.
My name is Elena Semper, E-L-E-N-A-S-E-M-P-E-R, and I took the oath.
Thank you.
I'm here as a Valley resident because I feel what SoCal Gas representatives tell us alludes to their facility being safe, and it is not. I lived in the Valley since 1970 and was here during the major fire in the 70s, and I was in Porter Ranch on June 9th, 2016, when 2 fire trucks drove by on the way to SoCal Gas. There were 2 separate fires at their Aliso Canyon facility within the same week. I was in the audience of SoCal Gas's criminal pretrial hearing in Santa Clarita last Tuesday, and a Porter Ranch resident sitting next to me received a phone call from SoCal Gas to advise them of a gas leak that took place the previous day. I feel samplings such as this should be considered as reason why residents have given up on reporting odorants. The amount of calls to report should be irrelevant because what they smell and what's logged or what their equipment reports does not correlate. SoCal Gas is not natural, it's altered, but advertising makes it appear otherwise. It makes it appear safe. This really, it dupes the public, it dupes the community, it harms people. We hear it on commercials, we watch it on TV. You know, and here, I'm coming here speaking out on this because what you're doing is so wrong when I should be doing other things, but I'm educated in climate change. I trained with the Climate Reality Project. I've spoken on NASA's methane experts, and I actually went to the 21st Conference of the Parties in Paris, and I spoke to experts around the world. We're so behind in Los Angeles, you know, and I sit here and I watch this harm every day and hear what you have to say. Please consider converting to solar and wind. That's the only safe energy. Otherwise, you're misleading people. Valley residents discovered at the previous South Coast Air Quality Management District hearing that on average, SoCal Gas's facility leaks on average twice a day. The EPA confirmed danger in decades of unreported methane fugitive releases. I attended the joint agency workshop in Diamond Bar on August 26th, but since then another leak was reported. I was going to ask that since the pipe was above ground this time and outside of Dogger's jurisdiction, who do we talk to regarding that? Who do we confront if Dogger's is below the ground and this pipe was above the ground? We need to focus on converting to safe renewable solar and wind energy, and with Elon Musk's recent announcement of battery storage for Los Angeles' energy needs, and knowing the cumulative terrible harm of methane fugitive releases, we need to emphasize this, not securing pipes.
Thank you very much. Faith Mira, followed by Jane Fowler and Patricia Glick.
My name is Faith Mara, and I took the oath. I'm here with Save Porter Ranch. I also work with Food and Water Watch, and I got my master's in urban sustainability. Going through the quality notification plan, I noticed that the storage operations group, who will be getting the notifications for the infrared methane leak detection system, is fully run by SoCal Gas. I also noticed in the proposed settlement that the money goes to hiring 6 positions to oversee that equipment that's paid for by SoCal Gas. SoCal Gas is responsible with their negligence for the largest gas blowout in U.S. history, and they get to monitor this stuff. That seems unbelievable to me. They stated earlier today that on September 12th, about 1,900 cubic feet of methane was leaked. That's the equivalent, as far as greenhouse gases go, because methane is 36 times more potent than CO2, to 202 cars being on the road for a year. The original gas leak, that was equivalent to over 500,000 cars being on the road for a year. All this other stuff we're doing as a city to try to make a difference, and this is what SoCal Gas is doing. That's unbelievable. This affects everyone, and I'm ashamed that this is even happening here in our city. This gas, we've proven with within the last few months of California switching to daily balancing versus monthly balancing, that we don't need this gas. All right, we don't need this gas. SoCal Gas needs that money. And this is unacceptable. And I can see your representative hasn't looked any of us in the eye while we've been speaking.
Watching
In the
screen
eye,
right here.
why we're speaking about this.
Right there and right there.
That's all I have to say. I think that's all I have to say. So if there's any questions.
Thank you very much. Jane Fowler, Patricia Glick. And yes, they were watching you on the screen.
Hi, my name is Jane Fowler, and I'm a resident of Granada Hills. And I don't feel well today, honestly. I was going to be here at the beginning, and I couldn't get out of bed, and I couldn't leave the bathroom, which tends to be a problem many days. Something I realize is that every time I'm away, I start to feel better, and every time I come back home, I feel sick. And that now that we are, we have to be home, which, I want to be home, but I'm scared to be home because every day that I'm here, I feel like I'm progressively getting worse and worse. And I'm scared because when I go to the doctors, they don't know what's wrong. One doctor told me, maybe I needed a psychiatrist. I don't need a psychiatrist. I know what's wrong, and I'm scared. My beloved dog had draining from her nose, and then all of a sudden seizures, and she passed away. My cats are having hair loss. I'm having hair loss. This is not my hair. My hair has fallen out. My other cat, can't use the litter box when he's in Granada Hills. While we were relocated, which cats don't like, he knew where the litter box was, and before the leak, he knew where the litter box. But now that we're home again, bad behavior. He can't find the litter box, and the hair loss, and my dog dying is very upsetting to me. And then feeling the symptoms that I feel, it's so stressful. It takes a toll on your body. It takes a toll on your mind. You start to think you're going crazy because you really want to live life and, do the things you want to do, but you're finding you can't do any of it. So I'm asking, please, to help us. I feel, that we're left to fend for ourselves, and you're the people who are responsible for air quality management, and I plead you to please help us figure out a solution so that, we can live healthier lives. And I just want to say also that I think we're sensitive. So if you're wondering why, things are capped and, it's just a little leak, it's just 2 leaks a day, we're sensitive. So any little leak, affects us, I think, more profoundly because we've been exposed over a long period of time. Thank you so much.
Thank you very much. We have one more, Patricia Gluck.
hard to listen to. Anyway, my name is Patricia Glick. I have taken the oath. The wells in Aliso Canyon were built over 44 years ago. The well that suffered the blowout was 63 years old ago, even older than I am. Some were built in the 40s. These ancient wells that should have been retired years ago are sitting on 2 active earthquake faults. Definitely residents of Porter Ranch, Chatsworth, Granada Hills, and Northridge have a right to be concerned, especially about our health. This is my new inhaler. I never needed one before last October. And many of us are in the same situation. We're still having respiratory problems caused by this facility, even 7 months after the well was sealed. You've heard about nosebleeds, severe rashes, the whole thing. My husband was just given blood pressure medication to use this year. He's always been the healthiest person I've known, so he's now having to take this medicine, probably for the rest of his life because of this blowout. Many people have lost their pets. Our neighbor lost their dog. It's sad to see that happen to our neighbors. And we have to be worried. Is this going to be a cancer zone, just like the area around Santa Susana Lab? There's already one parent whose child was recently diagnosed with aplastic anemia and is fighting for her life. This blowout is a nightmare for us parents. Our children will suffer because of a poorly maintained and mismanaged facility. I'm worried about my own daughter. SoCal Gas has never issued a comprehensive list of chemicals used in SS-25 over the years and used during the many attempts to cap it. The county didn't even know what exactly to test it for. Hazardous chemicals and compounds have spewed out from that well from October on, and maybe even before that. It's besides methane. These are toxic materials that are in our homes, our schools, our parks, our soil, our air. They have to be, because we're still getting sick. It's not just methane. And SoCal Gas has even admitted that there is an average of 2 leaks daily at its site. The gas company has already shown itself to be deceitful and secretive. In my opinion, it's also demonstrating bad faith toward my neighbors. It can't be trusted to run a safe storage facility, especially near some 180,000 people, and that's from 2010 census figures. Turmo Oil and Crimson have both had leaks up there this year. It's not a matter of if, when the next blowout will occur. Aliso Canyon is not a safe place. It needs to be shut down permanently. Thank you.
Thank you very much. No, thank you. Board members and Mr. Sanchez, Ms. Feldman, Mr. Carroll, Mr. Wyman. The purpose of, and members of the public, the purpose of today's hearing was to have an update on the status of compliance with the order that this board issued in January and then amended in February. That amendment was based on, or modification was based on testimony that we received from the public. And more recently, we heard from the public on August 6th some further concerns. The board asked that those concerns be addressed today, and we heard response to those concerns. The public testimony we've heard today has been far-ranging, some of it far beyond the limits of the order for abatement that is in play at the moment. Some of it, however, was right on point. And to that extent, I believe that the parties should be prepared to respond to those issues that are relevant to the status of compliance with the order for abatement. So we're going to take a 1-hour recess for lunch, and when we return, I expect to hear from the parties some testimony related to the questions that were raised today on the status of compliance with the order, and perhaps if they have some answers to some of the other questions that were raised that perhaps may not be relevant, but at least this is a place where they can hear some answers. That would be welcome. Senator, did you have a
Yes, sir,
point?
Mr. Chairman. Your comments are well stated and well received, but it was also my understanding and the public understanding that they would hear, provided for them today in the community, a report, a health report study, comments from a person qualified to speak on the health issue. And it was my understanding, and I think that was the case also.
If you're referring to the methane health issue, yeah. I have, well, let me back up. The district has provided on the district website a short, concise, and at the same time, right on point statement on the health effects of methane. The situation is the exposure is what is important. To what extent are you being exposed to methane? And methane, as pointed out, is relatively inert. The real issue, the complaints that the public has are with respect to the other components that came along with the methane, that come along naturally because they are added to methane to make it detectable at very low concentrations. And in addition, there might have been some additional components as a result of the gas being stored at pressure and then released at pressure, which may have brought along some other components that were not initially placed into the gas. So those are the things that really are what we should be concerned about, and to the extent that there are health impacts, those are the ones that the focus should be on, not the methane.
He wants to comment.
Dr. Lerner.
Yeah, may I just enter into this fray and make one further comment? Nobody knows, because there's never been any data presented. The assumption is that what is being delivered, purchased from out of state or in state someplace, the methane is 100% pure. We don't know that.
It's not.
Oh, is that true? Is that correct?
Natural gas is a combination of methane, has a little bit of ethane, a small amount of propane. It's a series of organic, of hydrocarbons, but the vast majority is methane.
I understand that. What I'm getting at is, to what extent do we know that those other chemicals developed in the process of fracking or extracting methane gas is not the contaminants that are causing some of these symptoms? We don't know, because we don't know what the product is that's being stored. We don't know how pure it is. We don't know when it's coming out. Is in the process of storage, something is happening in the process of transporting it out of the pipes, is being altered this pure, otherwise methane that came from someplace else. I think it's an open question. It may be beyond the purview of the hearing board, but we're not really talking about methane per se. That's already here. We're talking about something that possibly could be added, and that's my question, and maybe that's what other members of the board are beginning to think about, because it just doesn't fall into place. It just doesn't make a whole lot of sense from a medical point of view. Anyway, that's what I have to say. Thank you.
To that point, that's why this board early this year, ordered that a health study be performed, a thorough health study. And right now, it's not done yet. There's not agreement between the parties as to the extent of that, and there's some litigation. Okay, we're going to take 1 hour for recess and reconvene at 20 after
Mr.
1.
Chairman, before we do that.
Mr. Sanchez? Excuse me. Mr. Sanchez?
Thank you, Mr. Chair. As you've identified, there was far-ranging testimony that we received. I think it sounds like we're going down a path that is a little bit of concern to the district. The district has enforcement authority for public nuisance. We've provided ample evidence and testimony on how we've responded to complaints and measurements received in the community. We've been taken to task, and rightfully so, by this board and by the community for not doing more in the initial plans that we proposed. We've responded to that, as you've identified. That was the subject of today's hearing. Yes, there's contradictory testimony by the district and by the community, and there remain some questions by the board. It's very hard to identify what it is that this board is asking us to provide additional evidence on. We've responded to the specific questions raised at the last pre-hearing conference, responded to the testimony and the questions relayed at the last status hearing. And again, the role of the district is to respond to public nuisance. We have, by stipulation, identified things that go beyond the ability of the district based upon the current regulations on this facility and this industry as a whole. If the board can give some clarification on what it is they're seeking from the district, we will make our best effort to respond to that. But I just wanted to give that background to reiterate, I think, what you've identified, why we're here today.
Right. And you're correct. We did, as I pointed out, we've heard testimony that is really not relevant to the issue before us, the status of compliance with the order for abatement. We've heard about solar panels and other alternate fuels. That's not what we care about today. Perhaps to focus on one way we can do this is to, when we come back, is have the board direct questions to witnesses, and I would stress that those questions need to be within the confines of the order for abatement, so that we don't get off track into other things.
Mr. Chairman?
Mr. Lyman.
If I could speak to just one of the categories that came up, and to go back to Mr. Sanchez's comment at the beginning of the hearing, we don't want the board to spend time during the lunch break developing questions on the health study, because as the district has indicated and we have affirmed, that issue is no longer before this board as a matter of jurisdiction. I know that may be frustrating, but that's the law, that's the way it is. It can't be in two venues at the same time. It is right now at the district's request before the Superior Court, and so we will not be in a position to make any comment at all on the disagreement that the district has placed before the Superior Court. On the health effects issue, as we said in the very first hearing, this is not the ideal forum for trying to adjudicate the cause of individual health effects. That would require detailed medical expert testimony, discovery as to alternative causes of possible symptoms. It's just not, this board is not equipped, nor have the parties been given the opportunity that would be required to get into the question of individual health effects. And so, while it's certainly understandable that people would speak to that here, we would urge the board not to go down that path, because it's just not appropriate under the circumstances. And I think it does go, Mr. Chairman, to your admonition earlier that we should stay within the scope of the hearing. So I just thought it was important to say this before the break so that no one went to the effort of developing questions that we are not going to be in a position to answer for the reasons I mentioned.
Thank you.
Senator? They open up discussion again on this issue. In my view, the board can do what it wish, and you could challenge it. And that's what you indicate that you might do. But let me just, one question, Mr. Sanchez. That is, the governing board authorized money to be $600,000 to be spent with the National Academy of Science and Engineering for a health study. Was that done?
Yes, that went through committee, and the governing board adopted that proposal at a regularly scheduled hearing.
To me, that came from higher up. And then regarding the proposed settlement agreement on 2M, it's clear, given all the terms and conditions of this agreement will be required to be completed at or prior to the date of sentencing, including payment of maximum fine, et cetera, as well as the work specified above. LPD agreed not to seek or require probation on a condition of the agreement. You're saying all the other conditions must be met, including the health study.
That is a completely different action. The district is not a party to that action.
I understand who's a part of it, but the court is saying to me, as I interpret it, they cannot operate anything unless and until this is done. That's the court's statement.
That is a separate action?
I know it's a separate action, but it's saying to them, even if you complete all the other parts of the order, you still cannot operate until you satisfy 2M.
Thank you, Senator. We're going to take our lunch recess at this point. And when I'm going to ask for a conference just before when we get back, just before we resume, and to make sure that the instructions are clear and as to what we're going to do, what questions we're going to ask. Thank you. Mr. Sanchez, well, first of all, we're back on the record. Mr. Sanchez, Ms. Philman, Mr. Carroll, Mr. Wyman, and Mr. Gonzalez, I forgot for a moment. Here's how we're going to proceed. A couple of board members do have some questions regarding the status of compliance with the order for abatement. And I don't think that we're going to need witnesses for those questions. So we'll go through those questions and answers, and then when we come to an end on that, then we'll proceed with the closing statements. Any questions about that?
No questions.
Okay. So we have one more board member that's not here yet, so we'll go off the record. Thank you.
I'm good right now. It's good for him. He loves Max.
Oh, yes, that'd be great. Mike, do you want some more? Sure. Thank you.
I don't know if I told you the nice thing was Texas. I came home
These are from Chris. I can do that.
yeah, that's just it's like he raised yeah. I was like, hey, buddy, you missed me.
We're back on the record. Okay. The board has some questions, primarily for the Attorneys Council, but there is one question that will be directed to a witness for the district, and that's Ms. Snyder. So we'll start first with the questions for Mr. Sanchez. Ms. Prusak?
Mr. Sanchez, could you remind us, I know you spoke about this earlier, about the timing with regard to the declaratory relief that is sought from the court, so that we understand how long we're looking at before that issue of the health study is resolved?
Yes, I don't remember the date of the last, before the August 6th hearing when I first represented that we were pursuing legislation and litigation, but I believe following that 2 hearings back, we filed our action within 4 days of making that statement before the board. Since then, as I indicated, the discovery stay has been lifted, and I believe SoCal Gas is in the process of filing demurs to some of the complaints from the government agencies' complaints. And so all of these things are being handled, one at a time with that judge, so we don't have clarity at what time that hearing is going to be scheduled. So I don't have a definitive date, but the litigation has been moving in an orderly fashion. I will ask our counsel this week if they can give us a definitive timeline or try to ascertain a timeline from the judge in that court. And what I provided you earlier is in complex litigation, you are able to send messages amongst the parties, and that's how the court likes to handle communication amongst the parties. So we should have an avenue to request a question and get an answer, but there are a couple logistical and procedural things before our action may be heard, but I will do my best to get an update on when that matter will be heard by the court and provide that update to the board.
Appreciate it. Do you have any idea of time frame in terms of would it be before the end of this year, or you do not know that at this point?
I do not know that at this point, but the district continues to negotiate with the gas company to try to resolve that short of having to have litigation. Both parties, remain open to try to find some middle ground, and we continue to pursue organizing behind the scenes, whatever experts or NAS or whoever we're going to use. We're trying to not lose time as we move towards final determination of what it is we're going to determine is the appropriate study based upon the order and by the condition in this order.
So parts of the study are moving forward, or?
Selecting the method in which we're going to pursue this study is being evaluated on different fronts. I guess the best way to put it is we're not limiting ourselves to trying to get as much as we can accomplished through the ultimate determination of the declaratory relief.
Thank you.
Ms. Byrd.
I think I would address this to the respondent, but I also would allow the district to chime in if there is a way to coordinate. There were a couple comments made about how long it takes to get notice. One person saying that they were notified and it was a day later. And there's nothing in the plan that necessarily addresses that in the notification plan. And I don't know if that's something that could be addressed and placed in there. As well as there were some individuals, and I know that there will be some glitches that have to be worked out, but there were also some individuals who said they were on an email who did not receive notice. And so I don't know how you might want to address that, but maybe we could have something in the plan that at least addresses the timeliness of receiving notice. And I didn't know if you already have something that you consider to be timely as receiving notice or not. And you can just say yes or no if you do.
Mr. Carroll.
Yes. So with respect to the question of whether or not the timeliness of the providing of notice, as we've discussed, I'm sorry, let me state first that we have actually never had a release to date that triggered the notification requirements under the plan. So the notification, for example, that was provided related to the release on Monday was not done pursuant to the dictates of the Air Quality Notification Plan. We used the same database that's been compiled for the plan, but that was providing a courtesy notice for the information of the public so that they had information about what had transpired on Monday. And so that was not technically an implementation of the plan, and so I want you to keep that in mind. With respect to how we would implement the plan in the event of a reportable release, it does require us to do that promptly. And I understand the concern that that term is not specifically identified, but I don't know how we could possibly be any more specific about it given the myriad of different circumstances under which a reportable release could occur. And as I said earlier, I think some of them will be fairly straightforward, and the release will be reported what I think we would all consider to be very quickly, and in other cases it could take more time. For example, we need to obviously ensure safety of personnel, and there are some situations that could be more complex and could take more time. But we are committed to doing it promptly under the circumstances. Of course, the staff would always have the ability to question whether or not it was done promptly under any particular circumstance. So if the suggestion is could we build in a specific time frame, I don't see how we could possibly do that, just given the many circumstances under which a reportable release could occur. Not that we expect to have a lot of reportable releases, but we don't know what the circumstances might be.
Is it possible to use the word promptly and then have a phrase that follows something like, or at the very least within a certain amount of time, so that there could be something that the public can rely on when they're thinking that they are receiving information?
I really do not know how we could specify a bright line time frame for providing notices under all circumstances. I think promptly, I think that is a term that is, people generally understand what prompt means, and what it means can vary based on the circumstances, but I think both the gas company and the district would be in a position to look at the circumstances of any particular reportable release and make a determination as to whether or not the notification was provided promptly in those circumstances. And to be any more specific about it, I don't think is possible, given that we just don't know what those circumstances might be. With respect to the more practical consideration, there may have been some sort of a glitch. We heard one person who said that they received some emails but then didn't receive the email of the notification. That I can't explain that, because obviously their email address is in the database because they got the initial email. So if they didn't in fact receive the email on the 12th, I can't explain that. But what I would say is that any member of the public who's unsure about whether they're signed up, please contact the gas company or go onto the website and repeat the action, or call the gas company, and they'll help you ensure that you're in the database. But in terms of the couple of specific examples that came up today, I can't explain those. I would say it sounds like a lot of people received the notifications, which is good. That suggests that the system worked.
Following up on Ms. Bird's comment, perhaps not a bright line, but some kind of guidance that most of the time, the majority of the time, you would meet that. And I understand that you'd be reluctant to do that, because once you fail that, then people start complaining. But I think the words can be crafted that indicate that every effort will be made to provide that notice within a certain period of time. So that's not an absolute, but that's the guidance that I think would satisfy some concerns.
And maybe with some conversation with the district, I'm not sure if they might have some better understanding of how to hold them to that or not. I don't know, but it just seems like there has to be something that's a little bit more definitive than just saying promptly. Because promptly, while I heard what you said, but I disagree with you as far as what everyone would identify as promptly, or would define as promptly. I think that even sitting here, if we were to ask each one of the members here, we might have a different opinion of what is prompt. And so I think that maybe there has to be just a little bit, firm that up a little bit more. There was also something said from the public. A public member talked about, not a public member, but someone from the public who spoke to, in their email, I think it said, this is a courtesy notice. And while I think that may have been well-intentioned, any notice that the public receives that says there's a leak, they're not going to consider that a courtesy. They're going to consider that, well, yeah, you should have informed me of that. So if you are going to use that phrase, that might need to be defined within that email, even to say why this is courtesy versus mandatory. Because I don't think that is clearly understood. Even if I received an email and it said that something had happened, there was a leak, and this is courtesy, I would, I might start to wonder about, I'm just being real here.
Point well taken.
Yeah.
The intention was to convey that this was not a release of a magnitude that triggered the notification requirement. It's for informational purposes, but I completely... But I completely...
Excuse me.
I understand what you're saying, and point well taken, and we will look at the language for the notifications.
Okay. And I just want to mention this, and I don't know if it's possible or why it was not included, because I think we heard it last time, and I heard it today as well, that some people, when there were parents who mentioned that when their children come home from school, they find out later. I don't know if it's possible to notify schools. I don't know how to best get this information out, but if there is something that happens and you have your children at a location like a school, it would be nice, it should happen that the school would know that there was a leak, and maybe that might limit the exposure for the children being outside or whatever. So maybe that can be included. I don't think it's included under those entities that are notified. I saw, is LAUSD included?
Yes.
It is included?
It is.
Oh, okay, okay, sorry. Okay, that's covered. And that's all my comments. Thank you.
Ms. Prusak.
just...
I'm going to ask the audience to please refrain from interruptions. This is a legal proceeding, and I ask that you respect it as such. Thank you.
I was going to save this comment for our deliberation and discussion, but since Ms. Bird had brought up the word promptly, I just wanted to add the following, which is, Mr. Carroll is saying that you can't today tell us what is promptly, but that's because Mr. Carroll is not a witness with the knowledge to be able to do that. And for some reason, SoCal Gas did not bring a witness that could help us with that language or any language today. So it would be this was something I wanted to have done, to have the parties come back or to have SoCal Gas come back to us with some kind of guideline for what promptly means. And I also would suggest at least an outside number of hours or whatever that looks like, no longer than, et cetera, or I forget, Chairman Camarena, you had something that I thought was...
In no event later than? Was that?
No, it was even more... But anyway, something that could be worded like that, and with certain factors that would mean that there would be longer than Mr. Carroll, as you had said, in some circumstances it could be a few minutes. So what are the factors that would be accounted for so that we have some better idea of what promptly means? And I just wanted to add that to what was being stated, because I didn't have a question specifically, but just that we don't have enough information, and I think we need that information.
If I may respond to that, the reason that we do not have a witness here to speak to this is that the purpose of this abatement order, or of this status hearing, has been stated repeatedly, is to assess compliance with the conditions of the order. Member Prusak, you read the particular condition that we're talking about earlier. It requires the submission of a plan to the district and the district staff's approval of that plan. We have done that 3 times, and that demonstrates compliance with the condition. In our view, the hearing board has no purview over the contents of the plan, what the notification trigger should be, what the timing associated with providing the notification should be. Now, we've been very receptive to taking input from the hearing board and from the public, and as I said, we've now revised the plan 3 times in response to that. But that's why we didn't bring a witness today, is because we did not expect to get into this level of detail, because the condition says develop a plan and submit it to the agency and get it approved, which we did. We didn't see any need to bring a witness to testify to that fact. Had we provided a witness, that witness would be in no better position to predict the future than I am. They're going to say the exact same thing, which is, we don't know the circumstances under which a reportable release might occur, and therefore it's impossible for us to commit to any specified time frame. So that's why we didn't provide a witness, but I don't think it would have been helpful to have a witness here on the particular point that we're discussing right now in any event.
The fundamental reason for having a status report is to find out how it's going and to determine whether or not some modification of the order is needed. Ms. Prusek?
Yes, I mean, of course, I would respond that I disagree that any plan satisfies the specific conditions of the order for abatement that this board has adopted. But I'm not going to go into that just to disagree, but I would agree with Chairman Camarena that a status hearing requires witnesses. So I'll just leave it at that.
I didn't say any plan, a plan approved by the expert district staff. This agency has perhaps the most sophisticated expert staff of any air agency in the country, and I would respectfully suggest that you defer to their expertise. They have reviewed this plan and approved it.
We do defer to their expertise where that is warranted, but the word promptly is not within their expertise specifically.
Mr. Chairman.
Senator?
The burden is not on the district,
Yes.
in my view. The burden is on you to set forth the plan. This is your plan, Southern California Gas Company plan, and you responding to the order when you designed the plan. Now, it seemed to me at least that you've been giving a message that what's before us is not completely satisfactory in terms of reporting leaks. And to that extent, it may be, not that I'm saying that it will be, but it could be considered a need for modifying the plan to be more specific on that issue.
Well, I respectfully disagree. First of all, the burden is not on SoCal Gas. The burden is on the Air District in this matter as the moving party. And again, I would restate that what the condition requires is for a plan to be submitted and approved by the district. And I would also remind you again, the condition does not require any public notification whatsoever. And we have agreed to that on a voluntary basis. And if this isn't a case of no good deed going unpunished, I don't know what is. We could withdraw the plan and submit another plan that doesn't even include public notification, and that would comply with the order. As I've stated repeatedly, we have gone above and beyond when it comes to this plan. We have submitted and gotten approved now 3 versions in response to comments on requirements or provisions that clearly are not requirements of the order. And I just think it's inappropriate to continue to pursue the specifics of these issues when the district staff has reviewed and approved the plan.
Ms. Brissette.
Does the district have any opinion on the wording in terms of the word promptly as it is stated in the current version of the plan?
If we can just take a minute, Ms. Prusek. Thank you. We've identified the issues in the plan that we feel we're lacking, and we're responsive to the board's and the community concerns. With that being said, there probably is some imperfections in the plan, and the district never loses its ability pursuant to the Health and Safety Code to seek a violation of any condition within an order for abatement issued by this board. We had specifically been trying, following the last hearing, to get a quantifiable, objective standard on when a leak would be reportable to the community. As SoCal Gas has indicated, we've expanded upon which was initially contemplated by the condition in the order to notify the public if there were a release. That, coupled with them being under a criminal settlement and the definition of the word promptly, we do have a reasonable expectation that they would have to evaluate and make sure that any registering on that monitoring would be a valid one. Obviously, we wouldn't want to be in a position creating panic, whether it be to a parent or to a community member, especially as we've heard from the testimony today, this community is reasonably on edge based upon what they experienced. And so we have confidence that the definition of the word promptly, combined with a measurable detection limit as defined in the order pursuant to the criminal settlement, could be satisfied. And if we got to a point where there was any dispute of that, we have relief available either through enforcement or as defined in the Health and Safety Code to seek relief.
Thank you, Mr. Sanchez. When appropriate, I guess my suggestion will be for this board to consider either today or at a later date extending our jurisdiction so that these issues that remain, including the health study issues, the issues of the question of the what is a reportable release, that limit, that 10 ppm limit, whether that's stringent enough, and the promptness issue, we can continue to monitor that.
Did you have any other questions? No. Anyone else? Senator.
A question, Mr. Sanchez. Mr. Sanchez, the governing board spent $600,000 for independent guideline study. Was that done?
We have not entered into the contract yet based upon the dispute with the gas company and are alleging that dispute to pay for the contract given authorization by the governing board.
The hearing board so authorized that the money be spent concurred with the suggestion of the governing board. Is that correct?
The order requires a health study to be performed and for Southern California Gas Company to pay for that study. There is no, and as often is not in these orders, there is no identification of a dollar amount. So the order required a study to be performed and for SoCal Gas to pay for that study. As a result of that, the district initiated a public authorization through the governing board's committee to identify the amount of money to initiate that process. Things then were not, agreement was not reached amongst the parties, and so rather than pursuing payment of public funds for something that has not yet been determined, we stopped pursuing that process and we filed a lawsuit in Superior Court to get clarification on that dispute.
What's the result of that lawsuit?
It has been filed. And
oh, yeah, that's right. You explained it earlier.
Yes, and just to add, I was informed that we anticipate or expect a hearing date to be scheduled between February and March of 2017.
Okay, fine. Is an independent guidance the same as the health study? That's synonymous?
I'm sorry?
Here's an independent guidance, like a guideline. That's what they're...
Is that in the order or from the governing board?
In the order. 16. which shows where they're spending the $600,000, purporting to spend $600,000.
Do you have the exhibit number, Senator?
That's the order is not before us, but I do have the document, which includes the order.
No, you're looking at the complaint,
That's-
not the order.
This one. Is that it?
No, I was looking at the complaint.
This is a complaint, Superior Court complaint, I'm sorry.
That's not an order.
Yes, the intent of the authorization for the expenditure of funds by the governing board was for us to secure independent guidance to determine what study or type of studies and how to go about identifying what would be needed to fit the unique release and contaminants from this event and the exposure to the community from the leak.
That study is not within itself. That guidance is not the health study. Or is it?
Correct.
Right, so therefore, couldn't you commence to do that anyway?
We could, but because of the litigation, we've determined rather than expending public funds and having a decision by the court that may determine we should have interpreted or the court may determine that we should have pursued it differently, we think it would be unwise to expend those funds until we get that ultimate determination from the judge.
Okay, the lawsuit with the DA versus Southern California Gas Company, Exhibit 22. It, as I said, 2M relates to parts of the health study, and there's a dispute between us and the gas company on the health study, who's going to pay for it.
That lawsuit does not have jurisdiction over these proceedings today, nor does it have jurisdiction over the complaint that we just discussed.
That is correct. The question is, does that outstanding dispute precludes continued operation at the Aliso Canyon? Or 2M is incorrect?
I don't believe there's any language in that condition that identifies cease and desist operating at the facility. Again, we're not a party to that litigation, so it's really not appropriate for me to comment on another agency's order or settlement.
So you don't want to comment on it?
I can't comment on it.
I'll ask Mr. Carroll. Mr. Carroll, based on the stipulated agreement or the terms within the stipulated agreement which preclude commencing operation at Aliso Canyon, or can you operate without having fulfilled all the terms and conditions of the agreement, stipulated agreement?
If you're referring to the agreement between SoCal Gas and the district attorney on behalf of the people of the state,
Exhibit 22.
That lawsuit and the resolution of that lawsuit through this agreement is outside the scope of these proceedings. I'm not going to comment in any fashion on the agreement or any interpretation of the agreement here.
It could be after January of next year then. Go ahead, carry on.
Any other questions? Just want to remind the board that we're trying to stay within the confines of the order for abatement, its implementation. Apparently not. Did you have? Pardon?
Just from the city. It's not the
Oh, yeah, okay. We did have a question for Ms. Snyder. I'd like to recall her.
I'm sorry?
We have a question for Ms. Snyder.
The district would like to call Dr. Snyder to testify.
I guess I'll ask a question. It's based on the testimony that we heard and the questions that were asked by members of the public. The question is the 2-hour standard for response time to complaints that you testified about earlier. What is the time frame over which those response times were averaged?
With respect to the timeframes relative to Aliso Canyon, we looked at a time period from January 1st to February 11th, which was the date that the well was sealed, and then from February 12th to September 6th. So we were looking just within this calendar year, and then at the period of time before the well was sealed, and then the ensuing months afterwards.
And both had, according to the evaluation that you performed, both had a 2-hour average?
On the average,
response?
yes.
Did you have any response to, I think there were 2 members of the public who had gotten up and testified that one had said it took 24 hours before a response, and another, I can't recall how many hours, but was that part of your evaluation in terms of, did you also see that in the response times that you evaluated?
Yes, we did. And in fact, as I indicated before, in some cases, response times were very minimal, even under 5 minutes. Obviously, an average of 2 hours doesn't take into account variability. And so in some cases, we had a very prompt response, and in other cases, it was delayed or we were not able to respond.
Okay. And so the 2 hours is from the capping of the well to the current time. You're not talking about the last 5 complaints since the last hearing?
That's exactly right. We're taking them all in the aggregate.
Okay. Okay, thank you very much.
Mr. Chairman, I have one final question. Why would we be given Exhibit 22, which dealt with the proposed settlement agreement?
Pardon me?
This is not for Ms. Snyder, maybe we should.
No, I'm not asking you any questions.
For Ms. Snyder.
Yeah. Any other questions for Ms. Snyder? No. Okay. Senator?
I understood the senator's question, Mr. Chairman. The reason why I put Exhibit 24 and 22 in evidence, Senator, is because those events occurred following our last hearing. And the adding of the fence line monitoring condition as part of the updated air quality notification plan is pursuant to the terms in the Exhibit 22 settlement with the DA's office. At the last hearing, we had proposed a 50,000 cubic feet threshold based upon the district's fugitive emissions calculation guidelines to determine what level would a leak have to reach before notice was given to the community. The community didn't like that calculation, the board didn't like that determination, and so then we went back and discussed with SoCal Gas, could we come up with a better method, preferably a fence line monitoring with a specific measurement threshold. While we were in those negotiations, which they obviously could not share with us, they reached a settlement with the LA County DA's office. And so the terms of that settlement, we determined to be quantifiable and reliable in determining a level that could be measured to determine when a release should be reported. And so that is the reason why Exhibit 22 was presented to the board today based upon the highlighted sections which refer to that fence line monitoring system to be installed pursuant to that settlement.
Nothing in this exhibit that was highlighted.
No.
Not to me. And on that point, we can cherry pick what's in the proposed settlement and then decide to discuss portions of it that may or may not be applicable, but not all of it. And so being just a public member,
Yeah, what
I
I'd
don't
like
understand all
to,
that, except I see what I see is what I'm responding to. You shouldn't be in front of me if I can't talk about it.
what I'd like to direct you to is on page 2 of the attachment of the order, on paragraphs F and G, it identifies the infrared methane leak detection system.
Ms. Prusak.
I was going to ask that question because I think a member of the public asked that question. I'm not sure that they were provided with the settlement agreement. And the question was, and I would have answered it, but better that it come from someone possibly can answer with more authority. The question was, because that same infrared methane leak detection system now appears in the revised air quality notification plan, whether or not they didn't understand what that meant in terms of the number of monitors. So is it that paragraph F answers that question of 8 pairs of infrared methane monitors situated in strategic locations near or at the southern facility border?
Yes, that is correct. And all 5 exhibits that I introduced and we've been discussing today, copies are available to the public at our information table in the front, as well as this document and the air quality notification plan are posted on our website.
Mr. Chairman, I understand infrared technology, and I did read that last night. It just so happens, I was looking for something marked in red. You said marked in red. Maybe I didn't hear you. But you probably said infrared.
Infrared.
Or in red. Now I'm looking for what's in red. Infrared, I do understand.
Just a small correction on one of your statements, Mr. Sanchez. Exhibits 22 are not in, and 24 are not in evidence at this point.
I would ask that exhibits 20 through 24 be moved into evidence.
Mr. Carroll?
But not 22?
20 through 24.
Oh, they're all.
20, 21, 22, 23, and 24.
Okay, fine.
Any objection?
No objection, and at this point, as long as we're talking about exhibits, in reviewing the transcript from the prior hearing, I realized that we did not move Exhibit L, which was the supplemental declaration of Mr. Lefevre's, into evidence, so I would ask that Respondent's Exhibit L be moved into evidence as well.
Mr. Sanchez?
No objections.
Okay. Exhibits 20, 21, 22, 23, and 24, as well as Exhibit L, are in evidence. Any other questions, board members? Okay. We're ready to hear closing statements. Mr. Sanchez?
Thank you, Mr. Chairman. We were here before the board today to answer the questions as identified in the last pre-hearing conference order, specifically related to the air quality notification plan, as well as the leak detection plan. The district recognizes and by no way minimizes the individual health symptoms that members of the community are still reporting. However, the district has implemented, in reaction to the leak that happened at this facility, the most robust and comprehensive monitoring, surveillance, and detection system that has ever been implemented in any similar type of event. This event was significant, and the district's response to that event was equally appropriate. There is numerous actions going on, including a consolidated complex litigation action ongoing before the Superior Court. I provided Exhibit 24 to give the board some insight that some of the matters that this board is considering, that court is also considering. Expert witnesses, testimony, and advocates for the various agencies and the public have been appearing and arguing similar issues before that court. We are also litigating the health study in that matter. We haven't claimed victory in this event. We believe there's still things to be done. Clearly, when we started this proceeding, we were in the lead in addressing issues for an industry and facilities that were largely unregulated. The Aliso Canyon facility is under conditions that no other similar facility in the district and perhaps in the state are under. And we have implemented those conditions well in advance than the proposed regulations sought by CARB. The district does agree in some part with the testimony of SoCal Gas that they need to be given time to implement these conditions. The goal is not simply to implement conditions for the fact of saying we've done so, but to make sure that they're successful, that the district can verify they're being done, and that we monitor their implementation and success. Not only will the district be evaluating these things and seeking its own rules against this facility and this industry, the state will as well. Coupled with all these things, we've also provided the effect of methane, and we will ultimately be determining the impacts from the release from the well as part of the health study. It is not on the timeline that we had originally sought and proposed to this board. However, I think this board appreciates the fact that we've sought declaratory relief on this matter is significant. That is not something that typically happens, and it's something that we've stood by our word to make sure that it gets implemented as far as seeking funding from the governing board, regardless of our impasse with SoCal Gas. And we continue to try to negotiate to get the best solution for the best plan that will address this issue and give the community answers which they don't have today. Based upon that, we've determined, but for the health study, it's the district's position that they are in compliance with the conditions sought forth in this order. To follow up on Ms. Prusak's question, there is some unique requirements that varies in different conditions and different matters that this board hears. The two plans that the district has approved, the language in the order was for the SoCal Gas to submit and for the district to approve those plans. There are other matters where we have asked guidance from the board in weighing in on those plans or approving or disapproving them. We felt, based upon the resources and our involvement with other agencies in evaluating what needed to be done to remedy and prevent future odor nuisance events in the future, we were confident that we could review these plans and approve them for them to be implemented. Even with that being said, we identified and accepted that they could be made more robust and improved as we went through this process, and we were mindful and listened to what the issues the community raised. With that being said, we believe we're at a point that their implementation will achieve the goal that we originally sought before this board, which is to prevent and preclude any significant emissions coming from that facility that could result in the community experiencing an odor nuisance in the future. Thank you.
Thank you. Mr. Carroll.
Yes, may we go off the record for just a few minutes to consult?
Yes, we're off the record. We're back on the record.
Thank you. The abatement order that was approved by the hearing board based upon the stipulation of the parties goes well beyond abating the nuisance that was alleged in connection with the leak at well SS25. It requires implementation of a number of measures to enhance operations at the facility and to provide additional information to the public about the operation of the facility, many of which we've discussed today. We think that the board has been provided extensive information regarding the status of implementation of the order. And at this point, we do not see the need for any continued status hearings absent some change in circumstances. And we further would oppose any effort to either extend or expand the jurisdiction of the hearing board with respect to the current order. Again, the complaint that was filed in this matter by the district that resulted in this abatement order was based on a leak at well SS25 and an alleged public nuisance as a result of that. That leak was long ago sealed. The nuisance was long ago abated. We have, since that time, been working, again, based on the stipulation of the party on plans and requirements that are in the order and extend well beyond the abatement of the nuisance. But at this point, all of those conditions have been satisfied, all of those plans and protocols have been developed and approved, and we are in the process of implementing them. So again, we don't see any need for further status hearings or any basis for extending or expanding the jurisdiction of the hearing board over this matter. Thank you.
Thank you. Board members, it's been almost a year when I'm going to ask again that the process be respected. It's been almost a year since there was a large and continuous release of gases from a natural gas storage facility that took a long time to stop. Far too long. Since the initial release, there have been hundreds and hundreds of complaints of odor, of health effects, and that continue even today. This board issued an order for abatement that was stipulated by the parties to accomplish a number of things, some of which, the main one, the health study, was not really within the authority of this board to do, but we were able to have it placed in the stipulated order because the parties agreed to it. It was beyond our authority, but it happened. It's there. It's in the order. It must be done. Still isn't done. There's some litigation going on, and we hope that will come to a conclusion soon. Today is yet one more status report on the implementation of the order for abatement. Some of the items in the order were given to the executive officer to authorize. Why? Because, as Mr. Carroll pointed out, that's where the authority, that's where the experts are, not up here in this table. Listening to the complaints of the public, we feel we're frustrated, and we perhaps tend to get into the detail far too deep. I think it is appropriate for us to defer to the experts at the district. I think that it's our obligation to look over their shoulder and make sure that it's being done as we wanted it done. And while we can find little details that perhaps need to be refined further, certainly I agree with my fellow board members. I'm a little bit uncomfortable with the word promptly. I'd like to, I understand why there's resistance to an absolute bright line, because you cannot predict every circumstance that might occur, and there's always that risk of, okay, you went over the line just a hair, and now we've got a big issue again. The whole idea is to get it done promptly, to get the notice out promptly, and I still feel that some wording short of an absolute bright line can give a good guidance as to how soon that should be. Not a bright line, but a line that you should stay under 99% of the time. And I think for the most part, except for the health study, that very substantial progress has been made on the implementation of the order. Board members, Ms. Broussard.
I have a number of things to say. First of all, I just wanted to talk about the issues that we had asked the parties to come back to us on today, and to say that I was pleased with a lot of the information and the work that was done on many of the issues that we requested clarification on and further work to be done on, including the fact that at the last hearing there was a lot of confusion and expressions of not being confident in the 50 MCF level of what is a reportable release. The changing of that to the 10 parts per million is appreciated, particularly given that that seems to be a number that there's some comfort in on both sides, and I'm not sure how that will play out, which I'll go back to in a little bit, but one of the reasons why I'd like to see our jurisdiction extended so that, as you said, Chairman Camarino, we can continue to oversee the order that we granted and make sure that it is successfully implemented. Also along those lines, it is appreciated by this board, and I'm sure by the public, that SoCal Gas did go beyond the air quality notification plan that is required in Condition 11 and is including members of the public. Not only that, but to make it an opt-out, not an opt-in. And I appreciated seeing a streamlining in the decision-making process for what is a reportable release, because in my mind, the last iteration of this plan had far too many people to go through, many of whom seemed to be making multiple judgments on whether the release was reportable. Having this this more objective infrared methane leak detection system, and just one person who makes the decision based on that, and really shortening that chain of commanders, so to speak, I think was a definite improvement. Also appreciated Ms. Snyder coming back with the information that we had asked for with regard to complaint response time, and more importantly, the district increasing inspectors overall at the district, which will have an impact not only on the people who live around this facility, but all facilities that require inspection and those kinds of services. I also appreciated Phase 3 being extended beyond today, and the agreement with the LAUSD to go at least through the end of the school year, and a statement that the district is accounting for the fact that only 17 of the wells are currently back in full use and operation, and taking that into account for when they may move past Phase 3 and take down the remaining monitoring sites. So all of those things were appreciated. Of course, there remains a lot of frustration. And I wanted to just remark on the frustration that we hear, hearing after hearing after hearing, the people who live in this community and were so affected by this catastrophic leak. And I can only echo back the frustration, and I can only say for this board that we hear the frustration and we pay attention to the frustration, and that we are equally frustrated in trying to grapple with the fact that we have very limited jurisdiction. And as the district has put it, I think Mr. Sanchez put it, we are limited in that we only hear cases that are brought before us. In this case is for a nuisance of a particular well. We are not legislative in nature, and we've said this before. We can't shut down this facility. We can't regulate this facility. We can't, unfortunately, require solar or wind or any of those things, which I wish we could do. As the chairman also noted with regard to the health study, that would not be within our jurisdiction to require, and that ties our hands a little bit. However, with that said, I do want to say that this hearing board did have an option. The option was to not accept the stipulated order for abatement, which included the health study, or to accept it. And we, as a board, I didn't vote for that, but as a board, the board accepted with the health study. And I just wanted to state for the record, when I come back to the idea of possibly setting another status hearing, but certainly extending our jurisdiction, is that this board is not a rubber stamp. And this board, once this board adopts an order, whether it was stipulated and agreed to by the parties or not, it becomes our order. It is our order to make sure it is implemented as it was intended. And I have my opinions on how it was intended. However, I do agree that there is a proceeding right now, and that the district seems to be diligently attempting to clarify through the courts what is the health study that is required and what is the obligation of SoCal Gas to fund. And I think, unfortunately, while the words of this agreement might not be as clear as to what that health study is to entail, I do believe that the record is clear as to what was intended. But I'll leave that to the courts, and again, that's not within our jurisdiction today to determine. However, the last thing that I want to say, aside from, I echo Chairman Camarena, your reiterating the idea that I would like to see the word promptly set out more clearly, is I would like to bring to this board the idea of extending our jurisdiction, because by the end of January, we will not have a decision on the health study. We will not know where that stands, and that is a condition of our order for abatement. So how can we say that this order for abatement has been fully complied with? We absolutely cannot. So there is no reason not to extend it. And also the other things I'd like to see how the 10 parts per million reportable threshold and the promptly idea of promptly, or how it's written, how it plays out. So I think we need an extension of our jurisdiction for that reason too.
I failed to mention the reportable release definition. I believe that the new definition much more satisfies the intent of the words reportable release. I don't think we can find an absolute best, well, it's just a very difficult concept because there are high concentration releases that might be just pinhole leaks for a few minutes, or very low concentration releases that can go on for hours, days, weeks. So I think that the definition that the new definition the parties came up with, I think goes a long way to satisfying the intent of the intent. With respect to the response time, we need to take into consideration that when an inspector goes out, makes that first contact, okay, so many minutes or so many hours went by from the time that the call came in to the time the inspector made that first contact. When that first contact is made, there's a discussion between the inspector and the complainant. That takes time. And then the inspector has to verify that indeed, if there is an odor at that time, and it might have been gone by then, if there is an odor at that time, where is it coming from? And that takes time. Once that is done, on to the next complainant. And now maybe a couple of more hours have gone by. And so when we look at the response time, we need to take those factors into consideration, that the investigation does take time, and if there's 2 or 3 complainants at the same time, the third one, it'll be a while before the inspector gets to that complainant. With respect to the suggestions of alternate energy sources, well, yes, they're out there. But this is not what today is about. Today is about the problem we have at the moment and how to deal with it. Solar, wind, other energy sources, fuel cells, they're coming, but they're not all here yet. Ms. Bird?
Just had a few comments. You know, this is an unprecedented event. We're responding. There are unprecedented effects. And I am at least pleased with some of the efforts that have been made to move forward. One in particular that was mentioned by Dr. Snyder is that the effort to hire more inspectors and to have them in the area of Porter Ranch so that they could respond quicker if they are in an area where they live. I don't know that we could have anticipated or that anyone could anticipate that they would need to hire inspectors and locate them in a certain area to respond. A lot of things that happen and we have to respond to them. And without having anticipated that they would have to be hired. So I can appreciate that. And I can appreciate that we always have to look for improvement. As one board member, I know that I accepted or I voted for the stipulated order originally because of the health study, recognizing that we did not even have the authority to require that there be a health study. But that was the reason that we voted for it. I also mentioned earlier, and I still feel that there has to be some way to put a few more words to promptly. I don't know what they would be, but we, as a hearing board, we frequently encounter, at least for me, we encounter words that are just not clear to me, and I say, what does that mean? And sometimes we merely ask a witness to describe what that means, and it goes on the record, so at least we have a better understanding of what they think it means. We don't have that ability today because we don't have a witness. But I just think that we need to do a little bit more with that word. I also was pleased to know that we are extending phase 3, and that within the protocol or the procedures, there is always the ability to ramp up the testing, the monitoring, in the event that anything is noticed with the current level of monitoring. One of the things that will be happening, I think I heard it, that will be in November, introducing this new infrared monitoring, I think will be very beneficial. That was not anticipated the last time we were together, so I was really happy to see that. And I think that moving forward, that personally, I don't think I have a need to have a full-blown hearing for a status update, but some of the items that were mentioned today, if they are forwarded to the district and to the hearing board, would suffice for me.
Yeah, posting on the website, I think would be sufficient. Any other comments?
Yeah. In medicine, we have different categories of speed. One is called superstat, which means it's done as soon as you stop finishing the sentence. Then there's stat, which is the Latin abbreviation for statin, which means immediately. And then the other one is as soon as possible. All these things can apply once, what I want to say is we need to think a little bit out of the box about how to get the information once it's obtained. Obtaining it may take time. There may be elements of verification. But it seems to me that it sounds like it takes a long time to send out a lot of emails. So why don't we do something radically simple, which would never fly? But remember those World War II movies when the airfields were being bombed and the pilots had to scramble? There was a claghorn. And it just told everybody. Now, there must be a number of public buildings in the community where a horn could be just simply done. It could be sent wirelessly to the horn, which could trigger it off if there were a real problem with a leak or a smell that was spreading around the community. But get the stuff out to the community. And I believe you're doing it in good faith. You're not required to get it out, and you're doing it. So do something that might work better. And these people will they can't change the smell. You guys have to fix the leak. You other guys have to get rid of the smell. But at least let them know in advance. You could do this in every schoolhouse in the community, every church that has a steeple on it. There are ways of transmitting information virtually instantaneously. It sounds naive. I see one of the attorneys there is smiling at me. Yes, it is naive, but it's time to think out of the box. If we're going to take 3 days to get an email, well, gosh, that's not right. We all know it's not right. We're frustrated by it. You guys are frustrated by it. You're frustrated by it. We're frustrated by it. We don't know what to do. So think out of the box a little bit. Think of what are simple ways to do this. I'm not asking smoke signals. That's air pollution. We have enough of that. But that was a good way that the original people in the basin got together. But there are other kinds of smoke signals, wireless, to claghorns, to some other option that is available, that is obvious, that we're not thinking about. Okay, thank you. That's my comment.
Any others?
Yes, Mr. Chairman.
Senator.
I'm somewhat confused. And I'll tell you why. It was always my understanding that this is the only agency, the board hearing, this board, hearing board, would have the authority to shut down or close any operation in its jurisdiction for failure to comply or extremely negligent in meeting the goals and objective of the order. To say that that can be done, then that's something that I didn't know. Because I thought I read somewhere where this is no other agency can do it. The court can do it, and so can this board, is my understanding. If I'm wrong, I stand corrected. I need to be told that. Hearing nothing, then that must be the case. Now, let me just say something else. In the order, it was stated that the funding for the health study would be paid by the gas company. Am I correct? The governing board emphatically stated what their position is. They want to see it done. We came before this board, hearing board, they watered down the intent of the governing board. I'm going to repeat it. Watered down the intent of the governing board by inserting funding the reasonable cost, not just the cost. And that's what they've been hanging back on. What's reasonable is not being litigated. If you pay for the cost, probably wouldn't have that problem. Number one. Number two, gross negligence. As I understand it, I'm not a lawyer, I'm not going to even guess at it. Where there's bodily harm, that could be a felony. In this particular case, it's been just a misdemeanor. Nobody's scared of that. So I can tell you that after hearing this testimony today, I'm sick to my stomach. I'm very disturbed in the non-responsiveness of the claims these people are making about, no, I need no applause now. And I think that they're our citizens too. And we have a laboratory test about what's happened to them at a prior time that this thing occurred. 9/11, they're still dying. We don't know the extent of the damage that's been caused health-wise. We should not take it lightly. We should think about the way they feel. We listen to them. They don't think we have. That's why the respect for this body, and it should be highly respected. It's not that it should be, because they don't think we're responding to them. I think we are, to the best of our ability, but the fact of the matter is it doesn't meet that satisfaction. They don't think we're trying to be responsive to their concerns and their needs. I like to, since you're going to make a motion to extend this, retain jurisdiction, is that a motion that you're going to make? Okay, fine. I'd like to delete reasonable cost and just reasonableness and just my motion in the order and just insert the cost. Huh?
Any other comments?
I didn't understand. Delete reasonableness from.
Delete reasonable and just say fund the cost for it.
Oh.
Fund the cost.
Ms. Broussard.
Well, in some ways, I just wanted to respond, and maybe I'm oversimplifying things by saying that we don't have jurisdiction to shut down facilities. That's maybe overstating it. Well, let me finish. We do, and we do at certain points, let's say, okay? And it depends upon what's being brought before us and where we are in the particular case. When we're dealing with an order for abatement, we always have the ability to order that a facility stop violating rules of the district. And sometimes that might necessitate shutting down an entire business. We had that option. Unfortunately, in this case, we didn't really have that option because to shut down the facility wouldn't have stopped the leak. And when we first heard the case, the leak was going on. We had other options, but oftentimes we will choose the stipulated abatement route, which is what was chosen in this case, rather than saying, stop violating the rules of the district, which unfortunately couldn't have been done in this case. There were other things that could have been done, or in the alternative, comply with these conditions. These were conditions that were agreed upon by both sides, and as a result, we didn't need to find a violation. I think obviously we could have found a violation, but we didn't. And the reason why was, as Ms. Bird stated, for the health study, and for the very reason that we wanted that condition in there, or the board did as a whole, the majority of the board. And so now we have this order for abatement, and with the word reasonable is reasonable costs, as part of it. It was part of the stipulation. That was what was agreed to, and we can't take it out. And the reason why we can't take it out is because we don't have the authority to order a health study, either now or then, without the agreement of SoCal Gas, unfortunately, because that is not abating a nuisance, and that was our only authority. So unfortunately, we cannot agree to remove the word reasonable, or else we can't order any health study.
Senator.
Thank you, Mr. Chairman. In response, I'm not advocating, nor have I advocated, shutting down any business. What I'm in support of, cure the problem ASAP. If you know anything about my record, I work with, not against, mediation. It just so happens that it's been troubling me, and I'm sure you as well, when you hear the testimony, when you see what's happening to many of these people in their lives. It can't help but trouble you. And all I'm saying then is that if you can argue with reasonableness and delete that, the governing board heard these people and took a position reflective of the message that they gave them at that time. Otherwise, the governing board don't usually get involved in stuff like this. But they did. And to me, that's a signal. They want this situation addressed, not in a reasonable time, but ASAP. Failure to do that, be assured, and I repeat that, be assured there'll be a legislative action to remedy the situation if we fail to do so. If we fail to do so, as they say, God giveth and God taketh away. They created this body. They created this agency. Let the message go forth. Let the message go forth.
What would be your solution?
I want to delete.
Ms. Prusek.
I don't think we need to go down this road, but just to correct, the governing board did not create the hearing board, the legislature did.
I know.
Okay.
I said that.
Oh, sorry. And the governing board is required to, as part of the district, they're the ones who have to okay any payments by the district. And, you know, again, our order is our order, so any decisions need to be made by us, and they need to be within our authority. I don't disagree. I want more than anything for this health study to move forward, and to move forward quickly, and to move forward correctly. And it's my feeling that this board, and I've heard it from my fellow board members who in fact voted for the stipulated order for abatement, and it's their statement, and I believe it, that they did so, and I know we had discussion about this, because the health study is in there. And it's my belief that the health study was intended to be more than a health risk assessment, because health risk assessments are done all the time by the district, and they're stated as health risk assessments. However, we are where we are, and unfortunately, a court is handling how to interpret our order for abatement. Our order for abatement on its face is not clear, and so it is up to the court to review the entire record, which includes, I assume, what we stated in our deliberations. So I hope that will happen as quickly as possible, and that the district, as Mr. Sanchez represented, is moving as fast as they can on everything else that can move forward in it, and that it will be done quickly.
To the extent that the order may not be clear with respect to the health study, the board did discuss it, debate it during the deliberations in January and February. Because the board is not health experts, we left it in somewhat general terms, believing and knowing that through our discussion, it was clear that the board wanted more than a health risk assessment in the health study, that the board wanted to know, are the people being affected? To what extent? And that's what I hope will come out of the health study, some answers.
Mr. Chairman.
Sir.
That's what they're in court on this issue right now, and that's understandable. I can tell you this, you have to vote your conscience on this one. You've got to make a record, and I still stand by my motion to delete reasonable. So let's vote on it.
Mr. Chairman.
Did you say your motion?
Yeah, it says.
You made a motion?
Yeah, amended, delete reasonable cost. Just delete reasonable.
From?
From the order, 2C.
Mr. Wyman?
As Mr. Sanchez said at the beginning of the hearing, the record before the court on this issue has already occurred. It can't be affected by what's said today. And the issue is really not before the board today. We certainly agree with Ms. Prusik that procedurally it would be inappropriate for the board to change that provision. We certainly won't stipulate to it. You can't do it on your own authority. We don't really want to obstruct the board's discussions, of course. But likewise, we don't want to encourage any greater frustration than you're already feeling. We can certainly reassert, as you heard from the district, the gas company is actually quite interested in sitting down with the district and working these issues out, as we've said, I think, every hearing. And we are waiting to do that. And hopefully the district, upon hearing that, will get active. And we're hopeful that this is not something that will last for very long. But the course they've taken is to put the issue before the court, and we have to respect that.
Mr. Chairman, that issue is before the court. And the courts raised the issue, and the court pretty much took the position, according to stipulated agreement, that matter has not yet been resolved. That's the matter before the court.
There's a motion on the table. I haven't heard a second. He said he made a motion.
Who seconded the motion?
No, I said I haven't heard a second.
I want to delete reasonable.
Having not heard a second, the motion dies.
Mr. Camarena, I just wanted to add something, as the board's mentioned it in its deliberation. On the modified order issued on February 24th, on page 8 of that order, paragraph 33, the language indicates the hearing board shall retain jurisdiction over this matter until January 31st, 2017, or until respondent has met all conditions and increments of progress hereunder. whichever occurs first, unless the modified order is amended or modified. So consistent with what's been discussed by the board members, we feel that the board does have the authority, if the declaratory relief action goes beyond January 31st, that the board would have the ability to extend jurisdiction.
If I may just respond to that, as has already been stated by Mr. Sanchez, and I believe that Ms. Prusak concurs in this view, the matter of the health study is outside the scope of jurisdiction of the hearing board at this point and within the jurisdiction of the Superior Court. So to me, it's illogical that the board would extend the order to maintain jurisdiction over something that we think agreed to today is not within the scope of the board's jurisdiction. So if the health study, which is outside the scope of the board's jurisdiction, and we agree with the district that it is, then on what basis would you extend the order to maintain jurisdiction over something that you don't currently have jurisdiction over? Beyond that, I would just say that
Interesting point.
No, I think that's overstating what's been said here. The health study itself is not beyond our jurisdiction. It's in our order. It's number 12, condition number 12 of our order. It has not been done yet. This is, under no circumstances can I say that condition number 12 has been satisfied because there's still an issue. The parties don't agree as to the scope of the health study. What I did say was not within our jurisdiction at the moment, because it's before a court, is what is that health study as is based upon the record, and what a court determines to be what this body, as well as the parties, intended that health study to look like and the scope of it. That is the only thing that is beyond. But the actual requirement of condition 12 has not been satisfied. And so I don't understand how SoCal Gas can argue that this order can end, but this condition not be satisfied. I'm baffled as to how that can be argued.
Without taking a position as to whether or not the condition has been satisfied, the current order expires on January 31st, whether or not the conditions have been satisfied. So I don't agree with that interpretation. But let me just say, setting aside any specific basis upon which you might seek to extend the jurisdiction of your jurisdiction over the order, we're not prepared to stipulate to that. And of course, you do have authority to modify the order over the stipulation of the parties, but we believe that that would require you to file your own petition, since the alleged violation that was the basis of the petition that was filed in this case has been fully abated, and you in fact made a finding in your order of February that the leak had been permanently sealed. So in order for you to amend the order in any way over the objection of one or both of the parties would be to file a new petition alleging some sort of violation, to present evidence and make findings with respect to that violation. And then, of course, any modifications that you would seek to impose or any additional conditions that you would seek to impose through that modified order would have to go to abating the nuisance. So again, setting aside our specific objection to modifying the order with respect to the health study, and I stand by what I said earlier, generally speaking, we're not prepared to stipulate to any changes in the order, including the extension beyond January 31st of the board's jurisdiction. Our view is this was about abating a nuisance that resulted from a leak at well SS-25. That leak was long ago sealed. That nuisance was long ago abated. And we have continued in this process because we agreed to a number of measures that went well beyond abating the nuisance. And having made that agreement, it's appropriate that we've been here, but we're not going to support a further extension of the order.
So let me just ask Mr. Carroll. Mr. Carroll, let's take your argument to its logical conclusion. So your argument is this order ends regardless of whether the health study occurs. So assume there's not a decision by the court regarding the scope of that health study until after the order is over and dissolved. And so would it be your decision then, or would it be your opinion or your position that you no longer have to conduct the health study because the order that requires it now does not exist any longer? I just don't, I'm not understanding how that makes any sense, that this order which requires it will no longer cease to exist because the jurisdiction will not have been extended. Then there will be a decision by the court as to what that health study should look like, but then there's no requirement.
Look, all I'm saying is that if you read the language in the existing order, in paragraph, well, it's general condition number 3 on page 8, it states that the hearing board shall retain jurisdiction over this matter until January 31st, 2017, or until respondent has met all conditions and increments of progress hereunder, whichever occurs first, unless this modified order is amended or modified. So all I'm saying, I'm not taking any positions beyond this, all I'm saying is that under the terms of this condition, the order expires on January 31st, unless this board modifies it, and what I'm further saying is that we are not going to support a modification of the order, so that would have to be over our objection and take this matter outside the scope of the stipulated order.
Does it expire with your obligation to perform a health study? I think that's what he's saying too.
If I may just say with respect to that, our obligation is to make a commitment to fund the reasonable costs of a health study. So just so that we're clear on what the obligation is, we don't have an obligation to perform a health study here. Our view is that we have made the commitment to fund the reasonable costs of the health study, but we have not been informed of what the district thinks the reasonable costs of the health study are, other than that they don't agree with our proposal. But beyond that, we do not know what the district thinks the reasonable costs of the health study are.
That's right.
We've committed to paying them, but we don't know what they are because we have not been informed.
Mr. Chairman?
Mr. Carroll,
Sure.
if this board were to extend the order, then the stipulation would fall apart.
Yes.
Mr. Sanchez? Ms. Feldman?
Could we have a moment?
We're off the record.
It's in the record here, because I read it. I didn't bring it with me. No, but I mean, the point was that they agreed to their going to fund it. But this was the limited.
We should not have this conversation. Research this issue and tell you when we so easily agreeing to stipulated mutually and mutual. I'm sorry. Not, if you have questions about procedure or anything like that, you can always ask the clerk. Right. I like to answer questions, but I can't, we can't have discussions. My apologies.
I'm doing pretty good. How you doing? You got choked up?
What? Did I get choked up? Or did you get choked up?
I'm fine. Okay, let's go.
When we adjourn, welcome. When we adjourn, they've asked us to go upstairs while the audience clears up.
Okay.
And also our cars around. So
So they get me Starbucks? Will they get me Starbucks?
Oh, boy. Get back.
Good luck, whoever has to sit in my car, and my apologies in advance. No, it's not my child's fault. It would be my fault. Except whatever splattered on the ceiling. That was his fault. I don't know, some people are able to keep their cars nice and beautiful and clean. You do have children, and one still lives with you. Right, she has her own now.
Yep.
But it's not his fault. My boy is very, well, that's not true. He eats and throws his wrappers everywhere. But
I'm always in my car unknown, so. I can't find I must have laid it on top and got it fixed up.
we gotta be out of here at 4.
no, please.
Oh, it's after 3.
Yes.
I know.
At 3 o'clock?
I'll be there. And
At 3 or 4?
I'll be
4 o'clock, we have to be there.
It's always my fault.
I'm gonna have to go home and find
Got 45 minutes. I'm working with you on this stuff. Screw it up.
Yeah, that's a lot.
Unless they come back with some magical, just adjourn
Then what we'll do is,
and to consult with our city council.
I cannot believe how much we use our outside counsel. Our prior one left us because
No, that doesn't bother me. It may bother you, but if it does, it's fine. I just won't write.
We're back on the record. Mr. Sanchez, you asked, or Ms. Feldman, you asked for a timeout?
Yes, thank you, Mr. Chairman. We appreciate your indulgence and the patience of everyone in the room here today. The parties did have an opportunity to meet in the hallway about this and have decided on the best course of action going forward, given the apparent disagreement over the propriety of the board extending its jurisdiction. We don't have an objection to that. The gas company clearly does. Given the timeline that has been reported to us about the length of time it would take for the Superior Court to have a hearing on the health study and the district's prayer for declaratory relief, we are loath to agree that this hearing board should relinquish its jurisdiction prior to any determination on that. Given that, we believe the best thing to do is to set another status hearing in early to mid-January so that we can assess the need for this hearing board to extend its jurisdiction. Hopefully, the parties will be successful prior to that date in coming to an agreement on the nature and extent of what the health study should be. If that does not occur, the hearing board can then address the need to extend its jurisdiction beyond the January 31st, 2017 date. So we would request a hearing date in January of 2017, early enough for the hearing board to take that matter under consideration, with the understanding that the status hearing would be limited to that issue.
Mr. Carroll.
While we disagree with some of the statements made by Ms. Feldman leading up to the recommendation to set a status hearing in January, we do concur that that is the best approach under the circumstances, and we would support a status hearing being set for January for the sole purpose of evaluating whether or not the board is inclined to extend its jurisdiction over the abatement order. And if we are able to resolve the matter of the health study between now and then of course we could always take that hearing off calendar. I will also say, and this is moving a little bit off, but just to make sure that we put our full position out with respect to the promptly issue that we've been discussing, without making any commitments to modify the plan, because as I said earlier, and as I still believe, I'm not sure how we can be any more specific about it. We will commit to working with the staff to see if we can come up with some mutually acceptable language to put some more specificity around the meaning of the word promptly in the air quality notification plan. And if we are able to come up with some mutually acceptable language, then we would submit the revised plan to the hearing, once approved by the district, to the hearing board. So with respect to that issue, we are amenable to having some continuing discussions, again, without making any commitments to modifying the plan, but hopefully we could have some productive discussions and come up with some mutually acceptable language.
Would you commit to coming up with a revised or refined guideline for the word promptly by mid-October?
Yes, I think we can make that commitment.
That date acceptable to the district?
That's acceptable to the district.
Where's the date? I'm sorry.
October 15th, to be specific.
For another hearing?
No, that is the date by which the parties would report to the board, not at a hearing, but just a report on a, hopefully, an agreement on a refinement of the definition of promptly.
May I ask a question? May I ask a question? Mr. Carroll, Mr. Wyman, Mr. Gonzalez, any of you can answer this and put me in my place, but you're going to wait a month. You guys are going to figure out a month to define the word promptly. How about doing something different? I mean, why not just try and do something? Go back to your people and say, look, how can we speed up the process once we get the information? Why should and I'm not blaming you for the email thing, but it's clear that the email thing is not necessarily very effective when it comes 48 hours later. Why don't you think a little bit, why don't you ask your people to think a little bit out of the box? The word promptly would be satisfied by doing something different. It wouldn't be, that wouldn't be expensive, and you can come to us and say, here, this is our definition. Oh, by the way, we did this, this, and this. What do you think of that? That, I think, would be really kind of a creative, wonderful way. They would be happy, we would be happy, Ms. Feldman, Mr. Sanchez would be happy. You can make everybody happy, and you'd get some goodwill out of it without doing a lot. Anyway, that's my thought. Thank you.
Senator, first of all, let me remind the board members, we have to be out of here by 4 o'clock.
Okay, thank you, Mr. Chairman. Mr. Carroll, Mr. Wyman, you're good.
Can I, this is being recorded.
Yeah, let it be recorded. You're good, you're clever. This is a stipulated agreement. I was not there at the time that it was adopted, but certainly I would suspect, if the record would show, that you were responsible for deleting, for including reasonable costs. It's very clever. I don't think the hearing board members did. And I'm saying to you that that's undefined. It's a judgment based on who's calling the shots. That's all it is. In my work of labor, in legislative process, they call it loving it to death. How do we kill the idea? Love it to death. The death comes in January of 2017. The clock is ticking. This order will no longer be in effect. Then what happened? What's the effect of the order not being in effect? Of course, you can't come to an agreement. If you're going to come to an agreement in January, you can come to an agreement now. There's nothing that precludes us from doing that. But in old civil rights days, it says, justice delayed and justice denied. The fact of the matter is that the public can say, we've been denied due process by legal entanglement. And we can do better than that. Both parties can. And so I would say to you that that's the way they see it. And we have to be responsive and respond to what is known as due process. The clock is running. I don't blame those guys. They got to represent their country, the company. They don't mind running the clock. Then what you can do after that, file your own lawsuit, which I haven't heard you say you wanted to do. Maybe you got to say that. You know, it's called, how do I get your attention? I slap you. We have to get their attention as they've gotten yours, and you do good work. I mean, I'm not criticizing what you do. That's what you pay for doing. I want to applaud you. In all fairness, to be very honest with you. But the fact of the matter is that for reaction, equal and opposite reaction, we got to respond to that. And have the guts to do it, and the will. And where there's a will, there's a way. That we have to do for them, for those who are underrepresented or not represented at all. That's why we're here, you and all of us. They're not here for that. You do understand, don't you? Fine. I just had to say that because the clock is ticking. You won't have a leg to stand on come January.
Okay.
Chairman Camarena, the 15th of October is a Saturday. Perhaps you want to select a different date for the report back on the air quality notification plan?
The 14th, you said?
The 15th is a Saturday, so you're proposing October 14th?
I'm looking at 2017.
16.
This
Oh.
first one.
Oh,
We can certainly do it by then.
2017.
Sounds good to you, right?
May I propose the following Tuesday, which would be the next business day for the district? The 18th.
Parties in agreement on a date, and that is?
The 18th is fine.
18th of October. The 18th of October? Is that what you said? That is a Tuesday, correct?
Correct.
Okay. That'll be the day for the reply back from the parties on the refinement of the definition promptly. Okay.
If one can be agreed upon.
If. And then I'm looking at January 18th for a status report.
Will that give the board sufficient time to notice oh, that's setting the status hearing. Yeah, that's fine.
Right.
Sorry. Oh, that's fine.
Status report on January 18th. And that'll be for the purpose of evaluating whether or not to extend the jurisdiction of the hearing board. Okay. We need a motion.
The order will expire. What day will the order expire?
The order will expire January 31st
21st.
of 2017.
31st?
Yes.
We have 2 weeks cushion.
That is 2 weeks cushion. We need a motion on that? Yeah. I don't think so. Yeah. Okay. The board will order that the status hearing be on January 18th, 2017, and that on October 18th, 2016, the parties report back to the hearing board on the definition of promptly. By email is sufficient.
Mr. Chairman, record me voting no, it's just too long.
I didn't hear what you said.
Pardon?
I didn't hear what you said.
I said, record me voting no, it's just too long. It's just to delay, just to deny.
Thank you. We didn't take it to a vote. We just said it.
Okay.
But your objection is noted.
Thank you.
Okay. Any further business? Ms. Feldman?
Nothing further, thank you.
Mr. Carroll?
Nothing further. Thank you.
Board members? If not, we are adjourned. Thank you very much.